antibiotics, then that particular thing will trigger. So once that things will trigger, that particular gene will start to produce certain kind of proteins, and then that will lead to the cancer. So that person is prone to develop the cancer. So that particular person, we need extra care of that particular person कि cancer ना हो in future. So likewise, family में भी बोलते हैं, if we talk about any neurological disorders, if we will go to the doctor, a neuropsychiatrist or neurologist, he will ask about the family history. He will ask about the marriage कि आपने close relation में तो marriage नहीं किया है. So he just want to know कि either it is genetic from the gene it is coming towards this thing. अगर depression है किसी को, then again he will ask about the genetic makeup. कि depression है means family history है क्या depression की. So अगर सुसाइड किसी ने कमिट किया है, इट मीन्स वो फैमिली में है. अगर नहीं है तो मोस्ट लाइकली कि इन फ्यूचर उसके बच्चे और उस नेक्स्ट प्रोजेनी में कोई ना कोई प्रोन हो सकता है टुवर्ड्स दैट सुसाइडल बिहेवियर. सो इफ यू नो दैट दिस सुसाइड इज कमिटेड अर्लियर, दादा परदादा उस टाइम पे भी किसी ने किया था, इट मीन्स नेक्स्ट जनरेशन इज प्रोन. So you must have extra care about that. So people from the neuropsychiatric background, they are working on that, and once you will go to them, they will tell you, yes, this kind of thing will happen. So you must be have extra care of that particular person. But in general, अगर हम बात करें, we never care about that कि क्या है. तो अगर किसी ने सुसाइड कमिट किया, we will say गलत काम किया इसने, बहुत गलत किया, एंड जो बीबी बच्चे और या जो भी है या हस्बैंड है या बच्चे, उनको छोड़ के चला गया, क्या हुआ. So we can do or we can talk in that way, but what will be the condition of that person's mind who committed the suicide or even who committed the crime. So crime अगर कोई commit कर रहा है, what is the reason behind that, that we need to explore. But be a forensic people in the laboratory, these kind of things हम तक आती ही नहीं, हमको केवल एनालिसिस पार्ट करना है. But these kind of things, once you will do research, once the person who are doing in research in academics or in research institution, they have scope to do work in that particular area. So if we talk about the prefrontal brain structure plays central role in the regulation of aggressive behavior. Sometimes किसी का accident हो गया and there is a prefrontal cortex become damaged. After 1 year, 2 year, 3 year, even after 10 year, 20 year, that person may show aggressive behavior. So just because of that particular accident, person is normal, everything is okay. But just because of that accident, the person's behavior may change. That may reflect immediately, even within a month or even in a year, and sometimes it can be after 10 or 20 years. That person may be act like a aggressive person or a criminal person. So there are many researches carried out. People have carried out, people have worked, people have published paper that if prefrontal brain structures will be there, then the aggressive behavior may be there. It could be due to the major brain damage with substantial loss, mostly due to head injury, is associated with multiple dysfunctions, including aggressive or violent behavior. So if we talk about the forensic neuroscience, it is again the knowledge and application like all the scientific methods, but here we will talk about the genetics, behavioral science, and neuroscientific method for the investigation of criminal or vulnerable mind. So here we will discuss about the criminal and vulnerable mind. That's why in this forensic neuroscience, brain imaging, narcoanalysis will also be a part of this. But if we talk about the pro-criminalistic approach, then brain imaging and narcoanalysis crime ho gaya, after that we will analyze. But if we talk about the brain imaging, also after crime, जो भी criminal है, उसका हम करेंगे. But at the same time, if we will do the research, then those who do not committed the crime, उनका भी analysis हम कर सकते हैं, whether they are vulnerable to do these things or not. So that kind of research can be carried out. Provide biological data to reduce controversy in forensic psychiatric evaluation of mental insanity and minimize error in detecting malingering. Biological data will provide you the information that will reduce the psychological investigation or controversy in the forensic psychiatry evaluation. अभी क्या है कि लाई डिटेक्टर अगर करते हैं देन कोर्ट में एडमिसिबल नहीं है, just because कि जो person doing lie detector, that person will generate the report on the basis of data. So court is saying they are, court person or judge, they are not very much sure कि that person is not doing any tampering, that person is doing the right thing. So they are not very much sure, that's why they are not accepting the data, because data is generated by the system and the person is interpreting that particular data. So the interpretation may be vary. One person is interpreting that this is a criminal and one person interpreting that it may be a criminal, but I'm not sure. So these two things if happen, then court cannot give the decision on that. So that's why these kind of evidences are not admissible. But if we provide more data on the basis of lie detector, so that if the involvement of person will be lesser, but other than the biological data, biomarker or molecules will be there, like physical. जब भी न्यू क्रिमिनल लॉज में वैसे भी पहले भी ये आया है कि जो विटनेसेस हैं उनकी गवाही है उससे ज्यादा फिजिकल एविडेंसेस आर रिक्वायर्ड. फिजिकल एविडेंसेस जो कह रहे हैं that will be admissible at the same as compared to witnesses जो human है उनके witnesses से ज़्यादा physical evidences को ध्यान दिया जाए. In the same way, if we will provide the biological data or biochemical data or biomarker data, those will act as a physical evidence. So if the physical evidences will be there, then the court will be convinced. See, there are physical evidences, the human involvement is very less. So that kind of things may be here. So genetic, behavioral, neuroimaging, other source of evidences prove useful in advancing knowledge about men's. It is a kind of cognitive process relevant to deviant behavior. Information may be useful in forming psychiatric assessment. So psychiatric assessment means if we talk about the pro-criminalistic approach, in criminal trial, the evaluation of behavior disorder is required to establish the psychological profile of a suspect. Other than there is a question, presence of risk gene or neuronal abnormality could be the basis of any mental insanity or behavioral alteration. So if there is already some genes are present, some risk factor are there, some neurotransmitter alterations are there, so that person more likely to commit crime, and after commission of crime, the physical evidences will come to the laboratory. But if we will assess that particular person, that this is a prone to that particular criminal or aggressive behavior, so that treatment can be initiated and so that that person will not commit the crime. So that kind of approaches we can go through that. Pro-criminalistic neuroforensic approach, if we will go through the literature, go through the research paper, there are many papers coming in recent year that is based on the neuroscientific law, neuroforensic approach, pro-criminalistic approach, forensic and law. What is the role of brain in law, brain and law? So these kind of things are available and people are working. But if you will go through the literature from India, you will not found even a single paper. That is the thing. People are not thinking or not working in this particular area. So we must start to think. Once we think, opportunity and like one example, those who are they have they have to come this level. But other than that, they can go to the CSIR laboratory like Indian. they will not do the forensic, because once they will go to the CDRI people do not know about the, so they will are qualified, so you can do the work, there is no problem, but the topic I will tell you. So they will give the topic, and that topic makes the person, the student, that person will always think how that topic will correlate with the forensics. Once I will complete my PhD and I want to go to the academics, how we can correlate that? Then you will scientific method. That is used. So whatever they will do there, so that will all automatically interrelated. That needs on the expertise of that particular, how they can associate that, because I did my PhD in toxicology from Jamia Hamdard and IIT Harlan, and during the toxicology I learned about the F of forensics. But once I came out after the PhD, toxicology or substances, people who are consuming or expose that particular toxicant, if death occur, then who is responsible? Those persons, if death occur, if yes, if any, just because the poisoning, just because the exposure, if death occur, no one is liable to blame. That is also a kind of forensic pro forensic approach. People have to think about that, why this occur, because हमको केवल crime हुआ, lab में आया, हमको analysis करनी, but that is also a crime, but nobody is thinking about that, addressing that particular issue, why this is happening. People in foreign countries, those are from the criminology background, they are addressing the issue where the household जो डस्टबिन में जो कचरा और वट एवर द थिंग्स हम लोग डंप कर रहे हैं, जैसे यहाँ पे भी आपने यार आपके एरिया में भी देखा होगा, यहाँ से ले जाके एक विलेज के किनारे डंप कर दिया. If that villagers will be affected and someone will die or death will occur, who will be the responsible? Nobody will address that particular issue. So that kind of things should be addressed. That kind of things should be there. We should think about those kind of things. जैसे इंडस्ट्रीज हैं, इंडस्ट्रीज में क्या करते हैं कि दे आर वट एवर द इफ्लुएंट इज देयर, वो किसी भी पॉन्ड में, तालाब में, किसी भी नदी में दे इफ्लुएंट को बहा दिया उन्होंने, एंड वंस द पर्सन हु इज कंज्यूमिंग दैट वाटर, उसको कुछ हो जाता है, then those industry persons will not be responsible because they will not think, nobody will think about that. So these kind of things needs to address. अदर देन दैट तो आप लोग सब कर ही रहे हैं कि फॉरेंसिक साइंस में हम लोग क्या कर, बट दीज काइंड ऑफ थिंग्स जो हम लोग नहीं सोचते हैं, दोज आर रिक्वायर्ड. If we talk about the neuropsychological tool में there are many tools, back depression scale for the depression, risk assessment, suicidal assessment scale to assess whether there is a suicidal tendency. Suicidal, ये जरूरी नहीं है कि पर्सन ने सुसाइड कमिट किया हो, बच गया हो, सुसाइडल आइडिएशन ही आया, अगर आपके दिमाग किसी ने भी बोला मन कर रहा है सुसाइड कर ले, it means there is an idea about suicide, that person may commit. So immediate that person need treatment, because if that idea will come, it means that person may do that thing. Maybe recently last 10 years back, 14 February night में हमारे जो अंकल थे, he committed suicide. He was in PSC, 50 year age, 3 children थे, 25 to 28 की एज में, और उन्होंने सुसाइड कमिट कर लिया. बट बिफोर दैट ही रेगुलरली टॉकिंग विद देयर फैमिली, और मेरी मदर के साथ भी कुछ अच्छा नहीं लग रहा है, मन कर रहा है कि सुसाइड कर रहे हैं. बट वंस आई नो दैट थिंग, जस्ट 2 days बिफोर मैंने उनसे बात की आधा घंटे, एंड आफ्टर दैट हाफ एन आवर बात करने के बाद आई सजेस्ट हिम कि इफ यू आर नॉट फीलिंग दैट, यू कैन टेक मेडिकल लीव और आप घर जाइए थोड़े दिन, और यू कैन गो टू द सम न्यूरोसाइकेट्रिक के पास जाइए. लखनऊ चले जाइए, नहीं है तो भोपाल चले आइए, दीज काइंड ऑफ थिंग्स हैपन। इवन आई ऑल्सो सेड कि आप जाइए अपना थायराइड का टेस्ट कराइए, बायोमार्कर चेक कराइए, कहीं कुछ प्रॉब्लम है अंदर। बट इन 2 days आई बिकम वेरी बिजी, हमने उनसे बात नहीं कर पाया। आफ्टर 2 days आई आस्क माई मदर कि व्हाट हैपन, उन्होंने चेक कराया कि नहीं कराया जो मैंने बोला था। शी सेज कि उन्होंने तो ऐसे ऐसे कर लिया। दैट थिंग्स हैपन। so that kind of things can happen with anybody। और अब मैं आज जैसे if we talk about myself, तो मुझे कभी कभी आई फील गिल्ट कि यार अगर मैं कुछ करता शायद ऐसा हो जाता। बट फाइनली हम क्या करते हैं, जो होना था वो तो होगा ही, उसको कोई रोक नहीं सकता। दैट काइंड ऑफ स्टेटमेंट विल बी देयर। हम ही लोग बोलते हैं, सब लोग बोलते हैं। सो दैट काइंड ऑफ स्टेटमेंट में बी देयर, हो सकता है। बट एटलीस्ट वी कैन स्टार्ट, वी कैन थिंक, वी कैन इनिशिएट, वी कैन डू समथिंग। होगा वो ठीक है, बट वी हैव टू डू समथिंग। सो इन दिस वे इफ वी टॉक अबाउट द कोलंबिया सुसाइड, ये अभी 3 साल पहले कोलंबिया ने एक स्केल प्रिपेयर किया, सुसाइड सिवियरिटी रेटिंग स्केल, on the basis of who farmers who committing suicide। कोई फार्मर अगर सुसाइड करता है, उसका लीवर, किडनी, विसरा हमारी लैब में आता है। वी फाइंड आउट द मेथड ऑफ सुसाइड। हैंगिंग से मरा है या पॉइजन खा के मरा है? पॉइजन खा के मरा तो कौन सा पॉइजन? ऑर्गेनोफॉस्फेट था, पायरेथ्राइड था, इजिली एक्सेसिबल था, खेत में डालने के लिए ले गया और सुसाइड कमिट कर लिया। Why he committed suicide? Who is responsible for that? Person will say कर्जा बहुत था, फसल में नुकसान हो गया, फैमिली में बहुत प्रॉब्लम था, that's why he committed suicide। But we have carried out a study since last around 8 years, and we find out that people or farmers who are routinely use that particular pesticide, that pesticide lead to neurotransmitter alteration in their mind। and people are using pesticides since last 20 years। जो पर्सन है, वो जो बूढ़े लोग हैं, बुजुर्ग हैं, वो 20, इतने केसेस भी हैं। इवन सम पीपल आर यूजिंग लास्ट 10 year 5 year। so we collected data, I was in Sagar University earlier in forensic science department। we collected data from nearby the villages, blood and urine sample, and the person who are using pesticides since last 5 year at least, not like 1 year 2 year अभी just start किया। we collected data, and on the basis of data we give it that data, that blood to the thyrocare, so that कि हम अगर करेंगे तो बायसनेस भी हो सकती है कि हमारे माइंडसेट में है कि ये प्रॉब्लम है, ये होना चाहिए। सो वी गिव द डेटा टू द थायरोकेयर एंड टेक द रिपोर्ट, and same time we assess the neurotransmitter level। there was very less dopamine and serotonin in those farmers as compared to control। it means those who are routinely exposed that particular they are not committing the suicide at that time, but once they are exposing that particular pesticide, due to that the dopamine and serotonin will be less। and once if another trigger will be there, like फसल नुकसान हो गया, कर्जा हो गया, anything will happen, that person may commit suicide। so who is responsible for that? if they will not use that pesticide, or will use the limited pesticide, or will use the uh, precautionary measure while using the pesticide, that thing may not happen। so we are using with we are carrying out work in that particular area since last 8 to 10 years से मैं काम कर रहा हूँ। पेपर पब्लिश किए हैं, अवेयर भी किया है लोगों को, गांव में जाके नुक्कड़ नाटक एंड दिस काइंड ऑफ थिंग्स भी कैरिड आउट की है, सो दैट पीपल विल अवेयर कि व्हाई पीपल आर शिफ्टिंग टुवर्ड्स ऑर्गेनिक। आप में से अगर अभी बोला जाए, अगर किसी को अपॉर्चुनिटी दी जाए कि ऑर्गेनिक है, सेम रेट में मिल रहा है, नोबडी विल गो टू द रूटीन वेजिटेबल्स एंड। तो आप अगर बात करेंगे, सो मोस्टली पीपल आर शिफ्टिंग टुवर्ड्स ऑर्गेनिक। वाई? बिकॉज पेस्टिसाइड इज टॉक्सिक, पेस्टिसाइड में ये प्रॉब्लम है, पेस्टिसाइड में वो प्रॉब्लम है। बट एट द सेम टाइम वी हैव वर्कड आउट ऑन दिस पर्टिकुलर एरिया एंड फाइंड आउट कि इट कुड कॉज सुसाइडल आइडिएशन। ये आइडिया ऑफ सुसाइड क्यों आएगा? वंस देयर इज ए डिप्रेशन, and depression क्यों होगा? if there is a low level of serotonin and dopamine। and how this happen, low level of serotonin and dopamine? because of that pesticide exposure since last so many years। and not only that one thing, there are many other stressors also। तो इन्होंने अभी डेवलप किया दिस स्केल फॉर द फार्मर्स, देन सुसाइडल आइडिएशन स्केल, क्लिनिकल एंगर स्केल, देयर आर मेनी स्केल्स। so only these scales will not work। at the same time with the scale biomarker should also be there. क्योंकि if we go, if anybody, if you people or any family person, any friend will go to the neuropsychiatric department, they will assess on this basis, but they will never tell you go and examine the neurotransmitter level, dopamine का level check करा के लाओ, nobody will tell you. Serotonin का level check करा के लाओ, nobody will tell you. They will give you MAO inhibitor, SSRI, these tablets they will give you. What these tablets will do? These tablets, once you consume, they will block the degradation of dopamine and serotonin in our body. Ultimately, their level will be higher. Once the level will be higher, you will feel good. After some time, then again that condition will occur. Then again you will take the medication, then again you will feel good. So these kind of things will be there, and then afterwards you will be dependent on that particular drug. So that's why अगर ऐसा कोई केस होता है, कई बार हम लोग बोलते हैं आप योगा करो, आप टहलने जाओ, आप अच्छा खाना खाओ, आप ब्रेक ले लो, घूम के आओ, पहाड़ पे चले जाओ, आप फैमिली के साथ रहो, फैमिली दोस्तों के साथ. Why these things are going on? क्योंकि medicine will not work. Medicine will work for a temporary reason, but after that these kinds of work will be there so that कि आपका जो dopamine, serotonin, happy hormones ये सब balanced रहे. तो ये assessment is not only the thing कि on the basis of that हम ठीक हो जाएंगे. At the same time clinical biomarkers are also required, but neuropsychiatric जो MD भी हैं वो भी कभी नहीं कहते, because कोई मेथड ही नहीं है उस तरीके का. देयर इज नो मेथड कि आप मेथड है बट पीपल आर नॉट अवेयर अबाउट दैट, एंड बिकॉज ऑफ दैट अगर डॉक्टर बोल नहीं रहा है तो पैथोलॉजी लैब कभी उस बारे में सोच ही नहीं रही है. आप देखेंगे मेनी थिंग्स अभी कोविड के टाइम से अभी तक मेनी काइंड्स ऑफ नए नए टेस्ट आ गए मार्केट में. सो इफ दे सजेस्ट कि डोपामिन सेरोटोनिन का लेवल चेक करा के लाओ, इफ द सब कई बार क्या होता है कि there are other things, there is some disease in the liver, there is inflammation in the body, due to that depression हो जाएगा. ब्रेन में सब ठीक है, but just because of problem in the liver, kidney, inflammation, anything, the depression will be there. And that once you go to the neuropsychiatric person, they will give you the treatment of that SSRI or MAO inhibitor. That will alter the neurotransmitter level, increase the level, but initially देना क्या चाहिए था? मेडिसिन के पास जाना है हमको, एमडी मेडिसिन के पास, और उस इन्फ्लेमेशन का ट्रीटमेंट लेना है. Once that inflammation का ट्रीटमेंट से it will be okay, the depression will automatically subside. But that kind of things are not going on. उसके पीछे रीजन ये है कि साइकेट्रिक जो है वो डोपामिन सेरोटोनिन का लेवल की बात ही नहीं कर रहा. इफ दैट पर्सन विल चेक, आस्क यू टू चेक, तो अगर वो ठीक है, it means depression तो है, but that is not with the related with your brain. There is some other things. There are some inflammatory cytokines in your body. Interleukins है, inflammatory cytokines है, TNF alpha है. Those may be responsible for depression, not dopamine and serotonin. तो आपको ये दवा नहीं चाहिए. You have to go to the medicine people. बट ये होता नहीं है जस्ट बिकॉज कि रिसर्चर और नॉन मेडिको और मेडिको के बीच में कोलैबोरेशन नहीं है. दैट्स व्हाई. और कोलैबोरेशन है, एसजीपीजीआई में है, एम्स दिल्ली में है, तो वहां जब भी कोई जाता है बोलता है बहुत अच्छा इलाज होता है. पीजीआई लखनऊ रिफर कर दिया, एम्स दिल्ली रिफर कर दिया, बिकॉज दे हैव ए स्ट्रॉन्ग कोलैबोरेशन बिटवीन द रिसर्चर एंड मेडिको पीपल. सो दैट्स व्हाई ऑन द बेसिस ऑफ दैट दे डिसाइड द ट्रीटमेंट प्रोटोकॉल. बट इन जनरल ऐसे हमको नहीं पता चलता है. So not only on the basis of this, other than that there are some biological dimensions like oxidative stress हो गया, biochemicals हो गए, neurochemicals हो गए, genetic influencers हो गए, allele है, polymorphic value, ये predisposition susceptible to certain symptom of disorder. So now if we talk about the safest continent in the world, safest continent की बात करें या लो क्राइम रेट या जीरो क्राइम रेट की बात करें, एग्जिस्ट कर रहे ना इस दुनिया में. यूरोपियन कंट्रीज में क्राइम रेट बहुत कम है, यहाँ पे ज्यादा है. बोले यहाँ पॉपुलेशन बहुत ज्यादा है, ठीक है पॉपुलेशन ज्यादा है, बट क्राइम रेट क्या इतना हो जाएगा? मोर देन 100 टाइम्स वहां से. ऐसा तो नहीं होना चाहिए. सो दैट मीन्स दोज पीपल, उनका जो माइंड सेट है, जो डिप्रेशन, एंजाइटी, क्रिमिनल बिहेवियर, वो ठीक है. वो ठीक क्यों है? बिकॉज दे हैव ऑल द थिंग्स अवेलेबल. अभी हम लाल घाटी भोपाल में रह रहे हैं, हमको सीएपीटी आना है, 10 बार दिमाग में आएगा कैसे जाएंगे, ऑटो नहीं मिलेगा, ये नहीं मिलेगा, ज्यादा पैसा लेगा ये। इफ अगर गवर्नमेंट सर्विसेज हो कि हम जाएंगे बैठेंगे और पहुंच जाएंगे 5 मिनट, तो आपको सोचना ही नहीं है। आप रास्ते में जा रहे हैं, पोल्यूशन इतना ज्यादा है, दिल्ली का हाल इतना ज्यादा है, पोल्यूशन इतना ज्यादा है। सो दैट काइंड ऑफ थिंग्स कि हमको कहीं ना कहीं अफेक्ट करती हैं अवर ब्रेन, अवर माइंड को। अगर हम बात करें लो हैप्पीनेस मेजरमेंट इंडेक्स, द रिजल्ट शोज, ये एक पेपर आया, हैप्पीनेस एंड क्रिमिनल विक्टिमाइजेशन, स्टडी ऑफ रिलेशनशिप एंड रिस्टोरेशन, ये 2021 का पेपर है। पीपल आर वर्किंग ऑन दैट, जीएस वाजपेयी का नाम सुना होगा आपने, प्रतीक शर्मा। The result shows that people living in nations with high crime rates were less happy and satisfied than individuals living in nations with comparatively lower crime rate. Means crime rate के basis पे our happiness will be decided. तो just because कि हम ऐसे कंट्री में रह रहे हैं जहाँ बहुत क्राइम रेट है, हमारा हैप्पीनेस होगा ही नहीं। और जब हैप्पीनेस नहीं होगा, देन अगेन वी और अदर पीपल इंडल्ज इन द क्रिमिनल बिहेवियर। So that kind of things may happen. The forensic toxicologist का एक स्लाइड मुझे मिला था, a day in the life of a forensic, मे बी आप लोगों में कोई टॉक्सिकोलॉजी में काम करता हो। एयर पोल्यूशन एक्सपोजर इंक्रीज वायलेंट क्राइम रेट, ये स्टडी आया, हाउ एयर पोल्यूशन कैन कॉज क्राइम। सो दैट काइंड ऑफ थिंग्स आर ऑलरेडी गोइंग ऑन इन द सोसाइटी। So if we talk about Washington DC, in a new scientist have found that dirty air not only make us sick but also aggressive. So अगर आप दिल्ली गए, दिल्ली में जो भी जॉब करते हैं, दिन भर एक्सपोज होके आए घर में, तो लड़ाई करेंगे घर पे, बच्चों के साथ में, वाइफ के साथ में, फैमिली के साथ में, फ्रेंड के साथ में, वो कहाँ स्ट्रेस जाएगा। और अगर वो नहीं है तो ये धीरे 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 इट में कॉज सम क्राइम ऑल्सो। भाई अपने क्लोज रिलेशन में आदमी उनके साथ में थोड़ा सा नरमी से पेश आएगा, बट उसी समय अगर कोई नेबरहुड का आ गया कोई प्रॉब्लम लेके, उसके साथ में हो सकता है लड़ाई झगड़ा हो जाए, हो सकता है मर्डर हो जाए, हो सकता है फिर वो एविडेंस हमारी लैब में आ जाए। तो हमको क्या देखा हुआ, क्यों हुआ, हमको कोई मतलब नहीं है। बैलिस्टिक का केस है तो बुलेट मैच कर रही कि नहीं, अगर मारपीट का केस है तो कौन सा हथियार यूज किया गया। सो दोस काइंड ऑफ थिंग्स वी विल डू दैट, बट व्हाई दिस हैपेंस, so that kind of things is also required to address. That is the only point. Then that point को address करने के लिए stress, everyone is familiar with that. Stress क्या है, कैसे कैसे होता है, but my focus is that कि अगर हम stress की बात करते हैं, then toxic stress क्या है, कैसे वो toxic stress, a normal stress is required. Normal stress means क्या है कि once, अभी सुबह आपको यहाँ आना है, 9:30 बजे से क्लास है, तो आप सुबह उठेंगे, स्ट्रेस है कि सुबह जाना है, जाना, दैट इज रिक्वायर्ड। अगर वो नहीं होगा, नोबडी विल कम ऑन टाइम, दैट स्ट्रेस इज रिक्वायर्ड। अगर वो स्ट्रेस उतना नहीं है तो हम कभी कोई काम कर नहीं पाएंगे, दैट इज यू स्ट्रेस, ट्रू स्ट्रेस, वो रिक्वायर्ड है। बट व्हाट अबाउट टॉक्सिक स्ट्रेस, इफ द स्ट्रेस इज मोर देन दैट, toxic stress is not much about the cause of the stress but about the chronic and ongoing nature of the stress। वही अगर बहुत दिन तक चलता रहा, लाइक स्ट्रेस में एक कंडीशन है इमोबिलाइजेशन स्ट्रेस, पीपल आर वर्किंग ऑन एनिमल मॉडल ऑल्सो। उसमें क्या करते हैं, एक एनिमल को, एक छोटा सा रेट लेते हैं, उसको एक पाइप है छोटा सा, उसके अंदर ठूस देते हैं, उसकी जो टेल है वो बाहर रहेगी, और उसको टाइट कर देंगे, और 2 घंटे के लिए ऐसे ही रखा रहेंगे। तो दैट इज इमोबिलाइज, वो ऐसे करके बैठा हुआ है, इमोबिलाइज, नॉट, ही कांट मूव। After that 2 hour, that will give them for 7 days, 10 days, 28 days, depending on the type of treatment. After some time, after that, rat को sacrifice कर देंगे, मार देंगे, उसका brain निकाल लेंगे, and then assess the neurotransmitter level, genetic level. If we talk about the multinational companies, those companies has a 2x2 square, और person जाता है उसमें बैठ जाता है, पूरे दिन काम करता है, and then that is a kind of immobilization. अगर आप ही को यहाँ पे बिठा दिया जाए, बोले मूव नहीं करना है, बीच में जो चाय पीने के लिए जाते हैं, ये 2-3 दिन 4 दिन तक तो ठीक है, बट अगर ये महीने भर, 2 महीने, 3 महीने चलेगा, देन यू विल बी इन टॉक्सिक स्ट्रेस। दैट इज ए काइंड ऑफ ओनली वन थिंग। ऐसे ही रेड को स्विमिंग स्ट्रेस देते हैं, उसको स्विम कराया अनटिल अनलेस वो डूबने ना लगे, तब तक 1 घंटे 2 घंटे के लिए उसको स्विम कराया। स्विमिंग इज गुड फॉर हेल्थ, बट इतना भी नहीं होना चाहिए कि जब तक आप पूरी तरीके से पस्त ना हो जाए। So that kind of people are working in that particular area using the animal model, क्योंकि ह्यूमन पे नहीं कर सकते इस तरीके का काम, तो एनिमल मॉडल पे काम करते हैं। इसको थोड़ा सा मैं स्किप कर देता हूँ just because of time. If we talk about the neuronal damage in toxic stress, Here we can say in healthy brain, there are many normal neurons. If we talk about the toxic stress, just because of this stress, our neuronal death will occur. Neuronal death occur होने से मतलब ये है कि once the neuronal death occur, then the level of neurotransmitter will be less automatically. If neurons will not be there, then the dopamine, serotonin, GABA, acetylcholine, different kinds of neurotransmitter will be less. So once the neurotransmitter will be affected, then our behavior will be affected. Then again it will link to the criminal behavior or violent behavior or aggressive behavior. So this may lead to, toxic stress may lead to damaged brain. Neurons have fewer connections. Fewer connections से मतलब ये है कि 100 बिलियन न्यूरॉन्स के साथ एवरीवन, हम सब लोग जो है पैदा हुए 100 बिलियन न्यूरॉन्स के साथ आए, और सबने सुना होगा न्यूरॉन्स जो है वो रीजनरेट नहीं हो सकते, तो 100 बिलियन न्यूरॉन्स है उतने ही है। अब 100 बिलियन न्यूरॉन्स आपस में कनेक्शंस बनाते हैं। वो कनेक्शंस जो है, वंस देयर आर मेमोरी फॉर्मेशन, वंस वी आर लर्निंग न्यू थिंग, वंस वी आर रीडिंग द बुक्स, वन वी आर प्लेइंग द गेम्स, न्यू कनेक्शंस विल बी मेड। और वो न्यू कनेक्शंस इस बात को बताते हैं कि हाउ मच ब्रेन वी आर यूजिंग। इफ यू हैव मेनी न्यू कनेक्शंस, मल्टीपल न्यू कनेक्शंस, तो आपका ब्रेन एक्टिव है। और अगर कनेक्शंस नहीं है तो दैट्स व्हाई इट इज सेड यूज इट और लूज इट। अगर आप उसको यूज नहीं करेंगे तो वो लूज हो जाएगा, मीन्स वो खत्म हो जाएगा। सो जो आप देखते हैं कई बार प्रोफेसर्स को 80-90 ईयर की एज है, फिर भी बहुत एक्टिव है, बहुत अच्छे से काम कर रहे हैं, बिकॉज दे हैव मेनी कनेक्शंस। वो रूटीन में पढ़ते लिखते रहते हैं, उनका कनेक्शंस बहुत ज्यादा है। और कुछ लोग 50-60 की एज हो गई, उसके बाद कहते हैं कुछ नहीं रखा है, पड़े रहो एक किनारे। तो मीन्स दे आर नॉट यूजिंग देयर ब्रेन। यूजिंग देयर ब्रेन मीन्स बुक नहीं पढ़ रहे हैं, गेम नहीं खेल रहे हैं, एक्टिविटी नहीं कर रहे हैं। सो वंस दे विल नॉट डू दैट, द कनेक्शंस विल, न्यूरॉन उतने ही है, सबके पास उतने न्यूरॉन है, दे विल नेवर चेंज अंटिल अनलेस देयर इज इंजरी। इंजरी होगा तो न्यूरोनल डेथ हो जाएगी, अदरवाइज 100 बिलियन न्यूरॉन सबके पास है। दैट बिकम्स हाउ मच वी आर यूजिंग दोज न्यूरॉन, हाउ मच वी आर मेकिंग द कनेक्शंस विद दोज। ठीक है, कनेक्शन जितने ज्यादा बनेंगे उतनी मेमोरी फॉर्म, जो स्टोरेज होता है हमारी बॉडी में, जो भी मैं आपको बता रहा हूँ, सो न्यू कनेक्शंस अगर फॉर्म हो गया, मेमोरी फॉर्म हो गई, तो वो स्टोर रहेगा, अदरवाइज वो स्टोर नहीं रहेगा। तो दैट इज द रीजन कि टॉक्सिक स्ट्रेस के कंडीशंस में न्यूरॉन्स के जो कनेक्शंस हैं वो लॉस हो जाएंगे, और वो लॉस हो जाएंगे तो मीन्स की एक्टिविटीज जो है वो हैम्पर हो जाएगी। अदर देन दैट, इंसल्ट ब्रेन डेवलपमेंट, ड्यूरिंग ब्रेन डेवलपमेंट, ड्यूरिंग द फीटस डेवलपमेंट, 9 मंथ का जो पीरियड है, अगर वहां पे कोई भी इंसल्ट होता है, कोई भी प्रॉब्लम आती है, किसी तरीके का स्ट्रेस आता है, एनी टाइप ऑफ टॉक्सिक इंसल्ट हो सकता है, एनी टाइप ऑफ स्ट्रेस हो सकता है, एनी टाइप ऑफ एक्सपोजर हो सकता है। जैसे सपोज इफ एनीवन इज, एनी लेडीज जो है वो प्रेग्नेंट है और वेस्ट बंगाल गई, 1 महीने के लिए रह के आ गई, ड्यूरिंग दैट 1 मंथ आर्सेनिक कंटेमिनेटेड ड्रिंकिंग वाटर पिया वहां पे, और उसके बाद वापस से यहाँ आ गए और एवरीथिंग इज ओके। बट आफ्टर सम टाइम्स वंस द फीटस विल डेवलप, आफ्टर 5 year, 10 year, 20 year, there might be neurological disorder that may not seems immediately after birth. Doctors will never assess that, but after 10 year, 20 year, there is some neurological damage, maybe in the form of anxiety, maybe in the form of depression, maybe in the form of some other disorder. Then the researcher can link, yes, during that time exposure जो हुआ, that's why that is known as critical window। यहाँ पे ये टॉक्सिक एक्सपोजर है, डिजीज कंडीशन है, स्ट्रेस विद टॉक्सिक एंड एक्सपोजर है। So if we talk about this is the vulnerability, critical windows, critical windows में if we talk about conception to adulthood, there is a specific time. First neurulation will occur, neurogenesis will occur, microglia, synaptogenesis, apoptosis, ये these process will occur till birth and even after birth. But if any of the time, critical window के time पे, critical window means कि 3 month के टाइम पे, 4 मंथ के टाइम पे, 5 मंथ के टाइम पे, देयर आर सम विंडोज। सो एनिमल मॉडल में, ह्यूमन में भी साइंटिस्ट हैज फाइंड आउट कि दिस पर्टिकुलर पीरियड इज वेरी क्रिटिकल, few days of that particular time। अगर वहां पे कुछ प्रॉब्लम होती है, then microglial entry may be affected, then neurogenesis may be affected, then synaptogenesis, any of the things may be affected। तो ब्रेन डेवलपमेंट में अगर ऐसा कुछ हुआ तो दैट पर्सन में लीड टू क्रिमिनल और एग्रेसिव बिहेवियर इन ड्यूरिंग द एडल्टहुड, इवन आफ्टर दैट। सो ये सारी चीजें अगर होती हैं, देन नोबडी विल थिंक अबाउट दैट। जो एडल्टहुड में अगर किसी ने क्राइम किया, उसके पीछे की जो लाइफ हिस्ट्री है अगर ये है, तो nobody will think about that, nobody will talk about that, but actually these kind of things happen with that particular person. Then ये स्ट्रेसर्स हैं, इंडस्ट्रियल, केमिकल, हैवी मेटल, फिजिकल स्ट्रेस, रेडिएशन, ब्रेन इंजरी, साइकोलॉजिकल स्ट्रेस और पेस्टिसाइड्स, ये सारा हो सकता है। न्यूरोट्रांसमीटर्स का अगर अल्टरेशन, सेरोटोनिन लेवल डाउन हुआ, डोपामिन हाई हुआ, देन एग्रेशन हो गया। अगर ये दोनों लेवल डाउन हो जाएंगे देन डिप्रेशन हो जाएगा। एट द सेम टाइम हार्मोन का लेवल अगर अफेक्ट होगा देन एग्रेशन हो जाएगा। सो दीज काइंड ऑफ थिंग्स में हैपन। टाइम थोड़ा सा कम है, मैं इसलिए इसको कंक्लूड करता हूँ। ये डेविएंट बिहेवियर जो साइकोलॉजिकल का ही पार्ट है। वन इम्पॉर्टेंट थिंग जो ऐड करना चाहता हूँ मैं, ये अपने रूटीन और सोसाइटी और हमारी डेली लाइफ से भी इंक्लूडेड है। दिस गट इंटेस्टाइन इज ऑल्सो नोन एज सेकेंडरी ब्रेन, क्योंकि इसका स्ट्रक्चर आप देखेंगे दिस थिंग इससे रिलेटेड है, दैट्स वाई इसको सेकेंडरी ब्रेन भी बोलते हैं। आपको अगर कभी डिप्रेशन हो, एंजाइटी हो, प्रेजेंटेशन देना हो, आपका पेट खराब हो जाता है। अक्सर आपने देखा होगा, मोस्ट ऑफ द टाइम अगर ऐसा कुछ होता है ना, तो पेट कुछ कुछ गड़बड़ करने लगता है। दैट मीन्स देयर इज समथिंग रिलेटेड विद द गट बायो ऑर्गेनिजम्स, गट माइक्रोबायोटा जिनको बोलते हैं। तो जो गट माइक्रोबायोटा है, इस पे भी लोग काम करना शुरू कर दिए। तो गट माइक्रोबायोटा विल टेल यू कि क्या एक्चुअल में हो रहा है बॉडी में। ब्रेन को तो निकाल के हम काम नहीं कर सकते, बट गट बायो माइक्रोबायोटा वी कैन टेक आउट। बायोमार्कर्स जो है उसमें अवेलेबल है, यूरिन सैंपल है, फीकल सैंपल है। वी कैन एनालाइज द गट माइक्रोबायोटा एंड इफ देयर आर बेनिफिशियल बायो, जैसे तभी हम बोलते हैं ना प्रोबायोटिक्स, डॉक्टर्स देना शुरू कर दिए कई बार। दही खा लें तो हमारा पेट ठीक हो जाता है, प्रोबायोटिक्स ले लेते हैं। एंटीबायोटिक्स के साथ में अलग से इकोलाई दे देते हैं, अलग से बच्चों के लिए एक ड्रॉप आता है जिसमें इकोलाई होता है। So those kind of probiotics are available. People are taking those probiotics so that कि इंटेस्टाइन, अगर पेट ठीक रहेगा तो दिमाग ठीक रहेगा। अगर आपका सिस्टम ठीक है तो फुल डे आप ठीक रहेंगे। आप खुद इस बात को रियलाइज करेंगे कि सुबह सुबह अगर एवरीथिंग आपका ठीक से क्लियर है, देन होल डे विल बी ओके। और अगर पेट खराब है तो होल डे आप चाहे कितना भी काम करना चाहें नहीं हो सकता। पेट खराब होने से मतलब कि देयर माइट बी समथिंग, वो ऐसे खराब नहीं है कि आपको बहुत ज्यादा प्रॉब्लम है, बट आपका पेट सही नहीं रहता, देयर इज सम प्रॉब्लम इन द इंटेस्टाइन और गट बायोमैट्रिक्स, तो आपका सारे काम गड़बड़ हो जाएंगे। तो दिस इज ऑल्सो रिलेटेड विद द बिहेवियर। impairment of intestinal barrier, abnormal gastrointestinal motility, intestinal dysbiosis, and that may lead to depression, anxiety. ये जो सारा देख रहे हैं, that may be, that is associated with this also. Then माओ पे आप लोगों ने हो सकता है सुना हो, monoamine oxidase A and B. Many cases are reported in forensic science also reported. फॉरेन में जो लॉयर्स हैं वो अपने क्लाइंट को इसके बेसिस पे बचा ले जाते हैं। इंडिया में ऐसे कोई केसेस रिपोर्ट नहीं होते हैं, बट फॉरेन में बहुत सारे केसेस रिपोर्टेड है, मतलब पब्लिश्ड है, रिपोर्टेड है। वो ये बोलते हैं हमारा जो क्लाइंट जिसने मर्डर किया, इसका मोनोमीन ऑक्सीडेज जो है वो बहुत कम है। ये हमारे क्लाइंट के फिजियोलॉजी ही ऐसी है, हमारे क्लाइंट की फिजियोलॉजी ऐसी है, सो दैट माओ की लेवल कम है तो डोपामीन का डिग्रेडेशन नहीं होता, इसलिए डोपामीन हाई रहता है। डोपामिन हाई रहता है तो हमारा पेशेंट, हमारा जो क्लाइंट है वो हाइपर एक्टिव रहता है। अब अगर हाइपर एक्टिव में कोई इसको लड़ाई झगड़ा कोई कुछ करेगा तो मर्डर हो जाएगा, इससे हो गया इसको मर्डर, तो इसके लिए ये रिस्पॉन्सिबल नहीं है, इसके अंदर का सिस्टम रिस्पॉन्सिबल है, इसका मेकअप ही ऐसा है। तो जिसको फांसी की सजा हुई थी उसको नीचे आ गए, 10 साल की सजा हो, ऐसा नहीं बिल्कुल छोड़ देंगे, बट वो रिड्यूस कर। तो ऑन द बेसिस ऑफ दैट पीपल आर वर्किंग इन दैट पर्टिकुलर एरिया, जो साइंटिस्ट हैं या साइंस पढ़े हैं, लॉ पढ़े हैं, वो इस पर्टिकुलर थिंग को लेके अपने क्लाइंट को बचा ले जाते हैं। कई सारे केसेस रिपोर्टेड हैं, बट इंडिया मोनोमीन हमारे अंदर पहुंचता है, प्रिकर्सर्स पहुंचते हैं। जब भी डिप्रेशन होता है, एनी टाइम इफ देयर इज अ डिप्रेसिव कंडीशन, तो जो डॉक्टर्स दवा देते हैं, डॉक्टर्स विल प्रिस्क्राइब मोनोमीन ऑक्सीडेज इनहिबिटर, माओ इनहिबिटर। वो माओ को इनहिबिट कर देंगे, डोपामिन सेरोटोनिन बढ़ जाएगा। या फिर दे विल टेल यू आप बनाना खाइए, चॉकलेट खाइए, सोते समय गर्म दूध पीजिए, दैट ऑल आर प्रिकर्सर ऑफ दैट पर्टिकुलर न्यूरोट्रांसमीटर। फ्रूट्स खाइए, योगा करिए, सुबह जल्दी उठिए, वॉक पे जाइए, दोज ऑल ट्रिगर द लेवल ऑफ सीरोटोनिन एंड डोपामिन। तो अदरवाइज वो दवा देंगे, अदरवाइज ये चीजें भी करने को बोलेंगे। देन ये रोल है माओ का, लो है बेस्ड biased development of neural system circuit, adverse environment condition, hyperactive amygdala, फिर increase negative emotional, increase likelihood intensity criminal behavior, इस तरीके से हो सकता है। मॉलिक्यूल्स की अगर हम बात करें, सीरोटोनिन ट्रांसपोर्टर है, MOV A है, then catechol O, methyl trans, these are some molecules, biomolecules, those are available, and on the basis of that we can assess the vulnerability of a person, whether they will become criminal or aggressive behavior or anxiety behavior। और वन मोर थिंग, एक जो हम लोग अभी स्टार्ट किया है, जस्ट आई वांट टू शेयर विद यू, ये खत्म ही हो गया ऑलमोस्ट। अगर किसी पर्सन ने सुसाइड किया और केस आया फॉरेंसिक लैब में, फर्स्ट आईओ जाएगा वहां पे, फॉरेंसिक टीम जाएगी, एंड दे विल टेल कि ये सुसाइड है कि मर्डर है। तो देर आर मेनी व्यूज ऑफ द पर्सन, जैसे अभी सुशांत सिंह राजपूत वाला भी केस हुआ, तो पर्सन्स विल, सम पीपल विल से नहीं सुसाइड है, सम पीपल विल से नहीं मर्डर है। तो ये कंट्रोवर्शियल हो जाता है, एंड आफ्टर दैट ऐसे ऐसे करके चीजें दफा दफा हो जाती है। अगर कोई बायोमार्कर हमारी बॉडी में ऐसा मिल जाए, कोई मॉलिक्यूल ऐसा मिल जाए कि सुसाइड करेंगे तभी वो दिखेगा, सुसाइड नहीं करेंगे तो नहीं दिखेगा, ऑन द बेसिस ऑफ दैट इट कैन फाइंड आउट कि यस इसने सुसाइड किया और इसका मर्डर हुआ। ऐसे मॉलिक्यूल्स पे लोग काम कर रहे हैं, बट अभी तक कुछ ऐसा कंक्लूसिव नहीं मिला है। पीपल आर वर्किंग इन दैट पर्टिकुलर। अदर थिंग इज दैट अगर डोपामिन और सीरोटोनिन का लेवल चेक किया जाए, आफ्टर सुसाइड ब्रेन निकाला, ब्रेन का एक पार्ट लिया, एंड देन प्रोसेस फॉर द डोपामिन एंड सीरोटोनिन। इफ दैट लेवल इज लेस देन द कंट्रोल लेवल, व्हाई इट इज लेस? इट मींस पर्सन वाज इन डिप्रेशन। अगर लेस है इट मींस डिप्रेशन रहा होगा, तभी लेस है। सो इफ इट इज लेस देन दैट कंट्रोल लेवल, मोस्ट लाइकली कि ही वाज और शी वाज इन डिप्रेशन सिंस लॉन्ग वेरी टाइम, सुसाइड कर सकता है। और अगर वो कंट्रोल लेवल के बराबर है तो सुसाइड कैसे कर सकता है? सुसाइड के लिए तो डिप्रेशन चाहिए, सुसाइड के लिए तो एंजाइटी चाहिए, सुसाइड के लिए हिस्ट्री चाहिए, सुसाइड के लिए मॉलिक्यूल्स चाहिए जो ट्रिगर होने चाहिए, वो उसकी बॉडी में है ही नहीं। लेवल भी इसका ठीक है, इट मींस कि इट कुड बी ए मर्डर। तो पीपल आर वर्किंग इन दीज पर्टिकुलर एरिया, रिसर्च कर रहे हैं सो दैट किसी पर्सन के व्यूज पे ना जाएं, और अदर देन दैट जो फिजियोलॉजिकल, जैसे फंदा जो लगाया है या मार्क जो गले में है, वो सारी चीजें जो हैं, उनके अलावा बायोमॉलिक्यूल्स के बेसिस पे भी डिसाइड कर सकते हैं क्या, सो दैट कि वो पैरामीटर्स तो रहेंगे ही एज ए कोरबोरेटरी एविडेंसेस, बट अदर देन दैट पैरामीटर्स में आल्सो बी देयर, सो दैट हमको केस को और स्ट्रेंथन करने में मदद मिलेगी। ओनली सिंगल पॉइंट पे नहीं डिसीजन ले सकते, बट वी कैन ऐड ऑन सम पॉइंट्स। तो इस तरीके की चीजें जो है, जैसे क्रिमिनल जीन, द लिंक बिटवीन माओ एंड एग्रेसिव, इट इज ए काइंड ऑफ रिव्यू पेपर दैट इज पब्लिश्ड इन 2015। माओ ए जो हमारी बॉडी में है, मोनोमीन ऑक्सीडेज एंजाइम है, उसको बनाने के लिए जो जीन रिस्पॉन्सिबल है, दैट इज कॉल्ड क्रिमिनल जीन। अगर माओ को कम बना रहा है, माओ को ज्यादा बना रहा है, so that gene is termed as a criminal gene. So that's why on the basis of this, many cases in foreign countries people are working on this particular area और अपने क्लाइंट को वो छुड़ा ले रहे हैं, क्योंकि ये जो साइंटिफिक अप्रोच है, पीपल अदर देन दैट जनरली, जैसे लॉ पीपल है, मोस्टली आर्ट पीपल है, आर्ट साइड से हैं, साइंस बैकग्राउंड नहीं पता है उनको, वो इस एरिया में जाएंगे ही नहीं अनटिल अनलेस बहुत ज्यादा इंटरेस्ट ना हो या एक स्ट्रॉन्ग कोलैबोरेशन ना हो उनका। देन न्यूरोसाइंस इन द कोर्टरूम एंड इंटरनेशनल कंसर्न, इस तरीके के पेपर्स भी स्टार्ट हो गए आना। देन न्यूरोबायोलॉजिकल एस्पेक्ट बिहेवियर डेफिसिट इन फ्रंटल लोब फंक्शन एंड न्यूरोट्रांसमीटर। इस तरीके के पेपर्स भी आ रहे हैं, पीपल आर वर्किंग इन दिस पर्टिकुलर एरिया कि न्यूरोबायोलॉजिकल एस्पेक्ट क्या है वायलेंट और क्रिमिनल बिहेवियर का। अर्लियर बहुत थ्योरीज थी कि अगर ये जीन होगा तो क्रिमिनल बिहेवियर होगा पर्सन में, अगर बॉडी के फीचर्स पे बहुत सारी थ्योरीज आई कि बॉडी के फीचर्स में ऐसा होगा देन, बट दोज आर नॉट एक्सेप्टेड। आप किसी के बॉडी फीचर्स के बेसिस पे नहीं बोल सकते हैं कि ये क्रिमिनल बनेगा आगे चल के, बट बायोमोलिक्यूल्स के बेसिस पे देयर आर चांसेस कि आप बोल सकते हैं, क्योंकि दैट इज ए कॉन्क्रीट एविडेंस। बट फिजियोलॉजिकल के बेसिस पे कई सारी क्रिमिनोलॉजिकल थ्योरीज ऑफ क्राइम में आप देखेंगे, दैट्स व्हाई दोज आर नॉट एक्सेप्टेड 100%। अर्लियर दे वर एक्सेप्टेड, बट स्लोली स्लोली पीपल जो आए, जो उस तरीके का फिजिक है किसी की अगर, और बोला कि इस तरीके की फिजिक वाले लोग क्रिमिनल होते हैं, तो वो तो ह्यूमन राइट्स का वायलेशन हो गया। So that's why those theories were not accepted and those were not 100% true. So that's why these kind of neurobiological aspect or molecules or biomarkers are required to strengthen the things कि कौन criminal behavior या criminal tendency में जाएगा। एक पेस्टिसाइड वाला जो मैं बता रहा था, देयर आर रिसेंटली पेपर्स 9 में आया, देन उसके बाद 14 में आया, देन उसके बाद में ये अभी 18 या 19 का एक पेपर है। तो पेस्टिसाइड पीपल स्टार्टेड टू वर्क, इंडिया में कोई नहीं काम कर रहा, वी हैव स्टार्टेड इन सेंट्रल मध्य प्रदेश, हमने फर्स्ट टाइम रिपोर्ट किया, 3 पेपर्स भी आए, अच्छे पेपर्स आए। वी रिपोर्टेड दैट डिप्रेशन इज लिंक्ड विद द लो लेवल ऑफ डोपामिन एंड सीरोटोनिन, और फार्मर्स पे हमने काम किया। बट आइडिया कहाँ से आया? पेस्टिसाइड एक्सपोजर एंड सुसाइडल आइडिएशन इन रूरल कम्युनिटीज इन जेंजिंग प्रोविंस चाइना। आइडिएशन की बात कर रहा है, सुसाइड की बात नहीं कर रहे हैं अभी हम। पेस्टिसाइड खा के सुसाइड कर लेना अलग चीज है, सुसाइड का आइडिया आ रहा है, वो पेस्टिसाइड खा के भी कर सकता है, वो नस काट के भी कर सकता है, वो हैंगिंग से भी हो सकता है, बट दैट आइडिया, व्हाई दिस आइडिया इज कमिंग? so that idea is coming just because of this pesticide exposure। तो पेस्टिसाइड जो फार्मर्स जो सुसाइड है, फार्मर्स सुसाइड कर रहे हैं, वो एक रिट पिटीशन एमपी में हाई कोर्ट में हुआ था करीब 6-7 साल पहले, और कि सुसाइडल आइडिएशन पेस्टिसाइड एक्सपोजर से लिंक है, और वो रिट पिटीशन पूरा गायब है, कहीं नहीं अवेलेबल है, ना गूगल पे अवेलेबल है, कहीं पे भी नहीं है। बिकॉज जो पेस्टिसाइड फार्मिंग कंपनीज हैं उनका रेवेन्यू इतना ज्यादा है कि अगर उसको बैन करने की बात करेंगे तो कल को आ जाएंगे मेरे पास, क्यों आप कर रहे हैं ऐसा? उनको बैन करने की बात नहीं है, बात है पीपल्स को अवेयर करने की। पीपल हु आर यूजिंग दैट पर्टिकुलर पेस्टिसाइड, दे मस्ट बी अवेयर दैट हाउ मच क्वांटिटी दे हैव टू यूज। आप देखेंगे किसान को बोला 100 ml एक वो जो टंकी है उसमें डाल देना, वो 100 ml की जगह 200 300 400 ml डाल देते हैं, बोलते हैं क्यों? अरे इससे जल्दी कीड़ा मर जाएगा। दैट इज द प्रॉब्लम। पेस्टिसाइड यूज करने में प्रॉब्लम नहीं है, बट अवेयरनेस। ग्लव्स, अरे क्या करना है ग्लव्स, छोड़ो, हाथ से मिला ले। पीपल आर यूजिंग हैंड, बेयर हैंड। बोले मास्क लगा लो, अरे कुछ नहीं, गमछा बांध लिया, कुछ नहीं होता, 10 साल से यूज कर रहे हैं, कुछ हुआ अभी तक? कुछ नहीं होगा, कोई बायोकेमिकल कुछ प्रॉब्लम नहीं है। 10 20 15 साल के बाद ऐसा टेंडेंसी डेवलप हो जाएगी, उसके लिए कौन रिस्पॉन्सिबल होगा? So those kind of awareness, 95% people not using any protective measure, only 5% people are using. So these kind of जो idea है, societal ideation in occupational pesticide exposure among male farmers, risk factor, depression के साथ में, इन लोगों ने जो भी काम किया, that is on theoretical basis, just go to the farmers, data collect किया on the basis of skills, और उस data का interpretation किया। हमने जो काम किया, वी हैव कैरिड आउट द वर्क ऑन द बेसिस ऑफ दिस, इससे आइडिया आया, वी हैव कैरिड आउट बायोकेमिकल एनालिसिस, न्यूरोट्रांसमीटर एनालिसिस, उससे हमने बताया कि यस इट इज लिंक्ड विद द डोपामिन। नॉट ओनली कि आपसे पूछा सुसाइड का मन कर रहा है, उसने बोला हाँ कभी कभी कर जाता है, उसको हमने यस कर लिया, दैट इज नॉट द रिलीवेंट स्टडी। हम उसको जब तक बायोमॉलिक्यूल से कनेक्ट नहीं करेंगे, देन वी कांट से वेदर दैट पर्सन इज टेलिंग ट्रूथ और नॉट। तो आपसे हम क्वेश्चनर भरवाएं, आपको लंच में जाना है, भूख लगी, आप जल्दी जल्दी ए करके चले जाएंगे, दैट विल नॉट बी रिलीवेंट डेटा। रिलीवेंट डेटा के लिए हमको चाहिए कि ये फेस टू फेस इंटरव्यू इज रिक्वायर्ड, और फेस टू फेस इंटरव्यू में द पर्सन जो सामने है दैट शुड बी कंफर्टेबल, सो दैट थिंग्स रिक्वायर्ड। नाउ कम टू द रोल ऑफ एनएफएसयू। Just give me 5 minutes. To provide trained forensic professionals, जो NFSU का नेशनल फॉरेंसिक साइंसेज यूनिवर्सिटी का जो कंसेप्ट आया, ट्रेंड फॉरेंसिक प्रोफेशनल्स मींस कि वेरियस एरियाज ऑफ फॉरेंसिक साइंस जो है उनमें, क्योंकि ये केवल एमएससी फॉरेंसिक साइंस की बात नहीं कर रहा है, एमएससी साइबर सिक्योरिटी की भी बात कर रहा है, ह्यूमैनिटेरियन फॉरेंसिक की भी बात कर रहा है, फॉरेंसिक बायोटेक्नोलॉजी की भी बात कर रहा है, फॉरेंसिक टॉक्सिकोलॉजी की भी बात कर रहा है. To establish state-of-art analytical facility center for the analysis of physical evidences. Analytical centers से मतलब they have around 5-6 centers at Gandhinagar and they are also opening parallel forensic science laboratories. जो स्टेट और सेंट्रल की लेबोरेटरीज हैं फॉरेंसिक साइंस जो एनएफएसयू है वो पैरेलल लैब, जैसे गांधीनगर में जो एनएफएसयू है उसके साथ में एक लैब भी है एंड इन दैट लेबोरेटरी केसेस भी आते हैं और वो केसेस रिपोर्ट भी हो रहे हैं क्योंकि सेक्शन 293 सीआरपीसी में अमेंडमेंट के बाद में ए पर्सन हु होल्डिंग ए रैंक ऑफ सीनियर साइंटिफिक ऑफिसर और असिस्टेंट प्रोफेसर और मोर देन दैट दे कैन गिव ओपिनियन इन द कोर्ट. So NFSU का जो एम्प्लॉय है they can give opinion as per FSL and CFSL people. So that's why they are opening a parallel laboratory also. और उस laboratory में research based काम जो है वो होगा. To carry out the research and development for new method development, kit development, technology, strengthen the forensic science in India. आपके पास कोई केस आया and there is no method, आप उसको क्या बोलेंगे? Not detected. नया मेथड डेवलप करना है तो आप डेवलप करेंगे तो पूछा जाएगा ये एनएबीएल में प्रूव्ड है कि नहीं, एसओपी है कि नहीं, डीएफएस में है कि नहीं, आप कर रहे हैं कैसे मानने सही है. so you will do that, you will find out LOD, LOC, validate that and then you will recommend and then that will be incorporated with the help of NABL and then you can carry out the work. तो इसमें कितना टाइम लगेगा. so NFSU का जो रोल है that is like they will develop some kinds of method and they can recommend to the FSL and CFSL through the DFS so that वो उनके SOPs में include हो जाए और then people can start work in that particular area. To aware about the need of forensic expert at every field unit and also at the level of police station. जो अभी एक हमने amendment बताया न्यू क्रिमिनल लॉ में कि 7 year वाला केस एक है, more than 7 year punishment है, 7 और more than 7 at the पुलिस स्टेशन देयर मस्ट बी ए फॉरेंसिक साइंटिस्ट. तो जो मैन पावर जनरेट हो रही है, जो निकल रही है जो एनएफएसयू के डिफरेंट कैंपसेस से, so one appointment should be in the police station. It will promote teaching and research, conduct innovative experiment, develop new method and technologies in the field of technology, provide training, skill development, research and extension of work in forensic science, applied behavioral science, many science. क्योंकि नॉट ओनली द फॉरेंसिक साइंस, मेनी एस्पेक्ट्स जो है उनको ये लोग कवर कर रहे हैं. Status of INI, that is Institute of National Importance. If you will go to the UGC website, you will find out central universities, you will not find out NFSU because that is Institute of National Importance. That is INI category needs increase its national and global outreach. It is a kind of ITI, IIT's model. IIT's मॉडल पे है, इसीलिए इसका पे स्केल, इसकी सारी चीजें जो है दैट इज डिफरेंट एज कंपेयर टू सेंट्रल यूनिवर्सिटी. In order to create skilled manpower in the field of criminal investigation, national status will accommodate students across the country without any discrimination. जैसे आईसर हो गया, IITs हो गया, नाइपर हो गया, likewise NFSU is in the same category. So that NFSU से जो भी person निकलेगा, so that can easily accommodate in any institution across the nation. Then aims and objectives are like facilitate, promote academic learning, focus on skill development, foster research and applied application, promote and provide advanced institutional and research facilities, create capacities and capabilities of global standards. Status ये वाला हो गया. Coordinate with the central government and state government, coordinate and network with the institution having specializations, administer, maintain, manage the university, assist the central government, undertake special projects. The mission and vision is fulfill acute shortage of forensic experts in the country and the world because they are also opening the centers all over the world, not only in India. एक अभी युगांडा में भी इन्होंने सेंटर ओपन किया है. Make the world better and safer place to live, carry out research in the area of forensic science and its allied discipline. Education through investigation, impart high quality education, research in the area of forensic science, देन स्पिरिचुअलिटी को भी करते हैं. दीज आर द सेंटर्स ऑलरेडी इन गांधीनगर. एंड गैप एनालिसिस, ये पीपीटी में आपको शेयर कर दूंगा. गैप एनालिसिस इज एफएसएल सीएफएसएल में क्या गैप है, एनएफएसयू हाउ एनएफएसयू कैन फिल दैट गैप. तो ये आप लोगों के बहुत काम का है, लास्ट में आया. बट लैक ऑफ रेगुलर स्टाफ, जो अपॉइंटमेंट नहीं हो रहे हैं, स्टाफ नहीं है, वर्कलोड ज्यादा है. प्रॉब्लम रिलेटेड टू सैंपल कलेक्शन एंड प्रिजर्वेशन अकर एट द फील्ड यूनिट लेवल. फील्ड यूनिट में प्रॉब्लम है, लैब में एनालिसिस नहीं हो सकती. सो दैट इज पॉइंट नीड्स टू एड्रेस. Training to the field unit officers should be provided for handling the evidences. Validated kit for field examination. Kit available नहीं है, so that people can go at the field and examine at the field only. Not need to send the sample to the laboratory. वो kits की availability चाहिए. Uniform regulation for receiving the cases in the laboratory in both FSL and CFSL. कोई uniform paper नहीं है. So that you can carry out, you can do that. बस 2 मिनट परवेज जी अभी. बट दे माइट फील सम बोर. तो एफएसएल और सीएफएसएल में देयर मस्ट बी ए प्रोसीजर, और उस प्रोसीजर को टिक करना है कि ये है, ये है, ये है, ये यूनिफॉर्म है ही नहीं कहीं. पीपल अपने अकॉर्डिंग केस ले रहे हैं. कुछ बोल रहे हैं ठीक है ये वाला नहीं है, चलने दो, ले लो. कुछ बोल रहे नहीं ये नहीं है, वापस कर दो केस. So there must be uniform format and that should be applied to all the FSL and CF. और वो जो कंप्लाई कर रहा है उसी का केस लेना है, अदरवाइज नहीं लेना. सो यूनिफॉर्म रेगुलेशन अगर आ जाता है, यूनिफॉर्म फॉर्मेट आ जाता है, उसके लिए कुछ नहीं करना है. उसके लिए सिंपली एक फॉर्मेट बनाना है और अदर CFSL FSL पीपल्स के साथ में शेयर करना है. एंड देन गिव टेक द ओपिनियन, डायरेक्टर लेवल पे मीटिंग करके उसको फाइनलाइज कर सकते हैं. बिकॉज दैट इज अ गुड थिंग. तो इसको कर सकते हैं. बट दैट इज स्टिल नॉट देयर. यू पीपल आर वर्किंग, सो आपको भी पता होगा कि है नहीं है, क्या है. आई एम नॉट इन द फॉरेंसिक साइंस लेबोरेटरी, बट स्टिल बाय डिस्कशन विद अदर पीपल वी फाइंड आउट इस तरीके का प्रोविजन नहीं है. ICJS portal and CCTNS is not fully functional, therefore awareness and training is required. Then NABL accreditation is required. Some of the laboratories are not NABL accredited. कोई क्वेश्चन अगर करता है कि NABL accredited नहीं है, आप कैसे ओपिनियन दे रहे हैं, then again there will be problem. But ये मतलब अंदर की बात है एक तरीके से कि ठीक है, हो रहा है, नहीं हो रहा है, ठीक है, चल रहा है काम. But that's why people have started to take NABL accreditations. अभी तक नहीं था, नहीं है, चल रहा है, बट अभी people are aware and वो स्टार्ट हो गया करना. सो NFSU का रोल ये भी है कि एक्रीडेशन जो है वो जरूरी है, कराना है, नहीं है तो जरूरी है. Research and division section should be there in the forensic laboratories and separate scientific staff may be recruited. हमने लिखा है मे बी, ये हमने NFSU को दिया. एक मीटिंग हुई थी अभी महीने भर पहले के अंदर कि डिफरेंट फॉरेंसिक साइंस लैब से डायरेक्टर्स आए थे कि क्या होना चाहिए. तो रिसर्च लेबोरेटरी या रिसर्च यूनिट शुड बी देयर. So those who are interested in research, they can be appointed in that unit, and those who are not interested or doing the routine work, they can carry out the routine work only. But there must be option for those who want to do research. Otherwise क्या है कि जो रिसर्च करना चाह रहा है वो थोड़े दिन के बाद में फ्रस्ट्रेट होने लगता है, and people will think यार छोड़ो इसको, कहीं और जॉब करेंगे. So that kind of thing should not be there. ठीक है. Internship program may be implemented for forensic science student. Most of the laboratories में forensic science, MSc forensic science बच्चे को अलाउ ही नहीं कर रहे हैं, because they are saying इतना केस वर्क है, इतना वर्कलोड है, हम कहाँ से ले लें बच्चे को. वो बच्चे आएंगे, they will help you doing the analysis, but policies ऐसी हैं कि वो नहीं ले पा रहे हैं. तो पॉलिसी बनानी पड़ेगी डायरेक्टर लेवल कि किसको लेना है, किस बच्चे को लेना है. आप बोल दीजिए प्राइवेट सेक्टर से नहीं लेंगे, गवर्नमेंट के बच्चों को ले लीजिए. आप कोई टेस्ट लगा दीजिए, आप कुछ लिमिटेशंस लगा दीजिए कि वंस पर्सन विल क्वालिफाई दिस टेस्ट देन ओनली वी कैन टेक. बट होना चाहिए. अगर अदरवाइज जो न्यू कमर्स हैं वो एफएसएल में एंट्री कैसे करेंगे, वो हाउ दे विल नो कि क्या चल रहा है एफएसएल में. तो some of the laboratories allowing, some of the laboratories not allowing, but that must be in all the laboratories. Mandatory training for the scientific and technical staff on regular basis. Recruitment rule should be revised and BSc forensic science and BSc MSc. आप देखिए कई सारी यूनिवर्सिटीज स्टार्टेड बीएससी फॉरेंसिक साइंस, बट आरआर रूल में नहीं है. तो क्यों पढ़ा रहे हैं लोग. जो 12th पास करके बच्चा गया उसको क्या पता कि बीएससी फॉरेंसिक साइंस करना चाहिए कि नहीं करना चाहिए? क्या चीज? तो उसको तो पता नहीं है करना चाहिए कि नहीं करना चाहिए। तो ऐसे आरआर रूल्स अगर बने हैं तो एट दैट लेवल प्राइवेट इंस्टीट्यूशंस इतने ज्यादा है, मोर देन 90 इंस्टीट्यूशंस आर अवेलेबल इन इंडिया, दोज आर ऑफरिंग एमएससी और बीएससी फॉरेंसिक साइंस। तो वो जो है वो तो यही कहते हैं कि हमको this is the last slide. Pro-criminalistic approach needs to be explored in prevent or reduce the crime rate in the country. Scientific evidence and advanced technology needs to be included for the investigating purposes. And extensive research work with the valid output is required to strengthen the forensic science in the country. तो ये overall conclusion है, and this lecture is just to sensitize about the things what are going on, because you are already working in the forensic science area, and new criminal laws के लिए there will many faculty will come, those will tell you the main amendment and many things. So this is the thing. Thank you everybody. कुछ क्वेश्चन कोई क्वेरी हो तो यू कैन आस्क, और एनी सजेशंस हो तो आप। सर हो गया कंप्लीट।
Sir, may I ask a question?
कोई क्वेश्चन, कोई सजेशन, कोई चीज?
Yes, yes.
हाँ, छुड़वाएंगे नहीं, सजा कम हो सकती है। मतलब इफ देयर इज ए sentence till death, then in that case life that may reduce to life imprisonment, छुड़वा नहीं पाएंगे। बट अगर बहुत स्ट्रांग है तो उसको मेंटल हॉस्पिटल में शिफ्ट करवा देंगे। तो दैट इज ऑल्सो इंडिया में भी होता है समटाइम्स, अगर कोई क्रिमिनल है उसको अगर मेंटल प्रॉब्लम उसको डिटेक्ट हो जाती है, अगर प्रूफ हो जाता है कोर्ट में, देन दैट पर्सन विल नॉट गो टू द जेल, उसको हॉस्पिटल में कर दो, और हॉस्पिटल्स में देयर विल बी ऑल द फैसिलिटीज अवेलेबल। तो पर्सन जो है वो मेंटल हॉस्पिटल में जाना पसंद करेगा, वो बोलेगा जेल नहीं तो ठीक है मेंटल हॉस्पिटल में मैनेज करना। तो लाइक वाइज द जो भी सजा है, जो भी इम्प्रिजनमेंट टिल लाइफ है, उसको कम करवा देंगे। तो ऐसी चीजें हो रही हैं, एंड दीज एरियाज नीड्स टू एक्सप्लोर कि इसमें और क्या कर सकते
हैं। आपने जैसे बोला 100 न्यूरॉन्स रहते हैं एक इंडिविजुअल को, तो जैसे कि उसको डिमेंशिया हो गया,
I have a
न्यूरॉन्स को जो वो
I have a
हैं?
question, sir.
नहीं, हाँ, नंबर घटेंगे 100%।
Yes.
डिमेंशिया में न्यूरोनल डेथ हो जाती है, ठीक है। कनेक्शंस फॉर्म होना मींस मेमोरी लॉस होना। तो कनेक्शंस अगर फॉर्म नहीं हो रहे हैं, इट मींस पर्सन आर नॉट यूजिंग दैट पर्टिकुलर हिज और हर ब्रेन, जो जिस रिक्वायर्ड कंडीशंस में उसको करना चाहिए। बट इफ देयर इज डिमेंशिया, इफ देयर इज अल्जाइमर, इफ देयर इज एनी अदर थिंग, इन दैट केस, स्ट्रोक के केस में, इस्चीमिया के केस में, दैट पर्टिकुलर एरिया के न्यूरॉन्स विल बी डिजेनरेटेड, neuronal loss will be there. So other the neurotransmitter, like in dementia, mainly acetylcholine is responsible. So choline, acetylcholine will be given from outside, so that function will be normal. Like in Parkinson disease, dopaminergic neurons will degenerate, those will not be there. So L-dopa will be provided, so that dopamine synthesis होगी, और वो जब तक दवा खाएगा तब तक वो symptomatic effect will be there, but that cannot be cured, वो रहेगा ही रहेगा।
Sir, I have a little bit of suggestion. I want to clear it.
Yes, yes.
Yes. My question is, normally we have a 4 behaviors in the human population, and most of the stress we are giving towards to evaluate the intelligent quotient. but we have the spiritual quotient, we have the physical quotient, and we have the last, that is emotional quotient. Don't you think that the society all over the world is very vulnerable to the crime and all other things? That this emotional quotient should be also evaluated so that we can understand the behavior of the person right at its infancy stage of its development.
Sir,
Rather than we are, just like we say the Albert Einstein, the intelligent quotient are like Stephen Hawking, like that. But the times have changed, and there is a lot of bent towards the criminal behavior. That emotional quotient in certain population or in certain individuals should be evaluated so that it can be eradicated or arrested right at the infancy stage of its development. That's can it be possible?
sir, you have very rightly pointed out, and this is a very relevant thing that must be there. I am totally agree with you that emotional quotient is required to assess at the early stages so that we can find out the vulnerability of that particular brain of that person. But at the same time, the other thing is that whenever we are assessing the emotional quotient, we must assess the biomarkers also.
Yes.
So
We
those, if
must do
two
some,
things
we must do
there,
some study towards the biomarkers of that emotionality.
sir, there are already people have carried out, and we are also working on that, carrying out those things like serotonin, dopamine, and their metabolites like HIA, HVA, dopamine. There are many neurotransmitters. Those are associated with emotional quotient and also with the criminal and violent.
That is, sir, that is good. That is good. I mean, out of these four quotients, on three parameters, there's a lot of work going on. That is physical quotient, intelligent quotient, or spiritual quotient. But that emotional quotient, which is the backbone of for this all criminal acts or related to the behavior, I think that psychologists of the country or the psychologists, they should work on this part, that they should devise a formula or on the basis of analyzing the domain or serotonin or whatever else, or the physical features or the environmental factors, so that we can address towards the crime, because we understand that crime is everywhere happening all the time, and it is not possible for all of us to detect it. So it's a very, very vulnerable part. I think from this forum, that I think it should be a good suggestion if the people will work on that part. Thank you.
Sir, yes, you are very rightly said. And sir, people have started to work to assess the emotional quotient, and even in the police department also, people have started to carry out some workshop and training, workshop and seminar on the emotional quotient. How we can develop that, because that is very much required for the police persons also. So
Yes.
your point is very valid, and this should be incorporated.
Thank you. Thank you.
Yes, thank you. आप लोग anybody कुछ any thing you want to share, कुछ experience या कुछ ऐसा?
There is a new concept of the BCI, the brain computer interface.
हाँ हाँ.
So how that can be included in such type of pedagogy when we talk of these laws and all those things. Another thing is, in the era of artificial intelligence, when we have driverless cars, we have so many things which are dependent on artificial intelligence. How these laws can be implemented or augmented there?
Sir, this is a very recent technology using in the field of forensic science, artificial intelligence, because there are many pros and cons as already coming out. Because and once the data will be there, because at now this is a recent technology and data is not available, so we can't comment at present. But this is a matter of research. Ki data should be generated, and on the basis of analysis of data, we can find out whether these kind of things will be suitable in forensic investigation or not. So people have started to work and gathering the information, and it will take some time.
Okay.
Anything else? People are from forensic science. Anything if you want to share so that I can also learn something from you. incorporate
Yes,
in next.
yes,
Yes.
yes, yes. I want to share my experience of in the field of
Sure,
forensic
sir, please.
science,
Mhm.
because that is why these four behavior parameters came into my mind. Because most of the cases which I have done during my career, I have found, because while reporting the cases, I was in certain cases, I was very much interested to know the background of that person. And it was, I think, in 80% of the cases, more
Mhm.
than that, I think emotionally they were stressed out. And after that, that otherwise there is no other criminal behavior, nothing like that, but it is the stress or the emotional behavior or the emotional act which he has done, that he has done that act of sexual assault, murder, or something else. And that has been surfaced. I think most of the things, and that too, particularly if I talk of my UT, that is Jammu and Kashmir, this type of data, although it is not recorded, it is not published,
Mhm.
but that is out of my experience while examining the case. That is why I said to it, and you have agreed, sir, that this should be made a mandatory part of the curricular activity in the police or somewhere, that people should look to understand the psychology of the individual. That's my experience, which I have
Yes, sir.
shared.
Yes, sir. And sir, I would like to add one thing. You must write some editorial or some paper on that, some review article, some 1 or 2 page article, and publish that, so that peoples all over the world can be benefited from your thought, and that can give some idea that these kind of things may be there. So, if you can write some 1 or 2 page article and publish it in
That
online.
is, sir, that is true, because this is now newly touched subject. Earlier, that's what I was discussing with you. Earlier, people were not, even I, while noticing these things, had not found that it has some scientific background behind it. Other than we were only saying that what is your intelligent quotient. But this parameter has come it is coming fast on the surface of it is criminality or in the society, that we have to address it. That you are correct, sir.
Mhm. Yes, sir. Yes. Thank you, sir.
Thank you, thank you.
Any other query? So I think if there is no any query, we can stop the session here. Thank you, everybody. Thank you for your patience hearing. And thank you, CAPT, and thank you, Parvez Assistant Director and Additional SP, for giving this opportunity to interact with you. Thank you.
Thank you very much, sir, for sparing your valuable time and being with us, enlightened us on various issues, satisfied the queries of offline participants also, as well as online participants also. Thank you once again. Now, we should have a lunchtime break. Okay. So please come back by before 3 p.m. Good time, sufficient time, I hope. ठीक है, तो आपको you have to reach to Vindhyachal mess. It is adjacent to empty barrack. Okay, I will guide you. I will guide you how to reach. Not too far, hardly 200 meters distance. And for online participants also, please stay connected and join us again by 3 p.m. Don't leave the meeting platform. Okay, please. Can move.
लंच करा दे सर। अपने रोहित सर ने मांगे चिट्ठी, मैंने देता इस चिट्ठी का जवाब। ठीक, जवाब तक वही इसे हाँ डुप्लीकेट कोई इन्फॉर्मेशन हो सकती है। जवाब जाएगा इनको, तो मांग रहे हैं हम। मैंने बोला ना कि एड्रेस कर दो डीएसपी को और कॉपी कर दो हमें इन्फॉर्मेशन के लिए। मेल हम कर देंगे। अच्छा, मेल हम कर देंगे। ठीक है ठीक है ठीक है, हमारा जवाब जो डायरेक्ट बनाए। ठीक है हाँ, क्योंकि सवाल वो पूछ रहे हैं जो आप डुप्लीकेट को दे। ठीक है साहब, ओके वो ही तरीका ठीक है, वो ठीक है। हम भी खाना खा जाते हैं, तो अभी हम खाना खा के आते हैं। ओके ओके श्योर।
सारा शेयर करेगा ना। माइक सिस्टम का ही है।
दो में नहीं दिखता।
फोटो कर दो क्या, और स्क्रीन शॉट हो जाएगा, दिखेगा। और मतलब
तो इधर बैठा दो,
वैसे वैसे
इधर तो नहीं बैठ, या बेटर की नहीं, इस दो रो में कर दो।
2 रो में सही रहता है।
नहीं तो वो पीछे चले जाएंगे तो भी तो नहीं दिखे। या ऐसा नहीं कर सकते, इसको थोड़ा आगे बढ़ा के कैमरा।
करने से वो नहीं दिखेगा, और छोटा करने से ज्यादा स्पेस दिख जाएगा लोअर।
नहीं, ये ऐसा नहीं हो सकता है, यहाँ से कैमरा ले तो पीछे तक का अच्छा दिखे, उधर तो
क्या है
Welcome back again. Our next session will be on comparative legal framework, PNSS, Bharatiya Nagrik Suraksha Sanhita. For this, we have faculty Shri Raj Shekhar N, IPS, Deputy Inspector General from Bureau of Police Research and Development. He'll be joining through Cisco WebEx platform. We have received his message. He will be joining soon within 1 or 2 minutes. Before the start of the session, I would like to give a brief introduction about Sir. Sri Raj Shekhar N, IPS is an accomplished officer of the Indian Police Service belonging to the 2007 batch. Hails from Nagaland. With a career opening for several years, he has garnered extensive experience and commendable achievements in the field of law enforcement. During his tenure in Nagaland, he served as a superintendent of police in Longlang district, showcasing strong leadership and effective management skills in maintaining law and order. His commitment to upholding justice and ensuring the safety of the community was evident in his role as the Deputy Inspector General overseeing the ranges of Mokokchung and Tuensan. Raj Shekhar N has dedicated 4 years of his service to the Central Bureau of Investigation, where he exhibited exemplary commitment and professionalism. He is not only a seasoned law enforcement professional, but also an academically accomplished individual. He holds a bachelor's degree in commerce and a master's degree in political science. Additionally, his educational journey includes a master's in police leadership and management, highlighting his dedication to continuous learning and professional development. His expertise extends to the realm of business laws, where he earned a master's degree, demonstrating a multifaceted understanding of legal intricacies. Furthermore, he has specialized knowledge in the ever-evolving field of cybersecurity. He holds a postgraduate diploma in cyber law and cyber forensics, showcasing his commitment to staying abreast of contemporary challenges in the digital landscape. Presently, he holds the prestigious position of DIG Deputy Director in the Academy, where he continues to contribute his skills, knowledge, and leadership to the service of the nation. His diverse educational background and extensive experience make him a valuable asset to the Indian Police Service and a respected figure in the field of law enforcement. And for the participants who have joined through online mode, if you face any network issue or audio visual problem, you can raise your queries or you can write in chat box also.
इधर रहने दो, सीट in.
Afternoon, sir.
Good afternoon. Please start.
Sir, kindly increase your volume, sir.
Yeah. Now. Now, am I audible?
Yes, sir, but it's very low. Voice is very low, sir.
Now.
Now it is increasing, sir.
Okay. Please start.
The participants are from Madhya Pradesh, from Tamil Nadu, and through online mode, participants from JNK and Tripura have joined, sir. The volume is very low, sir.
कोई पूछने वाला नहीं.
Sir, you can share your screen also. You have presenter privilege.
Am I audible?
Sir, kindly continue, sir.
It is presented. PPT is coming.
The presentation is not visible, sir. It's coming. I think there is some bandwidth issue.
Share. Where is that share? I am sharing. Sharing. Content. Now. Now it is coming.
Parvez, is my
Yes, sir. Volume is clear, sir. You are audible, sir.
PPT is coming?
Sir, it's not visible, but written that is starting to share content. So kindly start, sir.
No. My PPT is not coming, no?
Yes, sir. It's not coming, sir.
There are 2 to 3 applications that is. I will close it. Now it is coming. It is not coming, Parvez?
No,
Yes, sir, it's not coming, sir.
visible, sir. It's not visible.
It's not visible, sir.
Let me share now. Now?
No. Yes, yes.
Yes, sir. Now it's visible. It's visible.
It's visible now.
Okay.
You can slide show the PPT there, sir.
Yeah.
Yeah, you can click on the slideshow there, sir.
Yeah. Dear participants, it is already the time. So I will go directly into the Bharatiya Nagarik Suraksha Samhita. This is the new name for the CRPC. And you know, there are some definitions that has been added. One is the audio video electronic means. That is the new definition for this one that has been added in section 2(1)(a). Always section 2 in most of the acts is the definition section. Bail here is 2(1)(b). Bail bond is 2(1)(c). The difference is bail bond is with surety, bail is without surety. Okay, electronic communication is the one new thing that has been come up, especially with the technology advancement of technology. Now we can file 0FR, UFR, you can file the police report, even summons, warrants, everything can be done in the electronic mode as well. Maybe notices, audio, even electronic videography. That means forensic, search and seizure also you can make the by electronic recording of this one. And another thing is that compared to the earlier CRPC, now the definition of the victim has been broadened. Now you need not to formally charge the accused person to consider that person as victim. This is the one thing. Next, investigation to clarify that in any case, if there is any difference between the other sections, that is there, always the special act will prevail. Now, coming to the judiciary. See, what is the set of hierarchy now? The top court, of course, is the high court in the particular state. Below that is the trial court that starts with the sessions court. Sessions court is the criminal court or the civil court. As you know, civil and sessions court it is called. When it is dealing with the civil cases, civil court, and it is the criminal, then it is a criminal court, district civil and sessions court. And below that, earlier there were two, additional sessions court and the assistant sessions court. Now, assistant session court is no longer available. So, sessions court, additional sessions court. Below that, maybe CGM court if the high court decides to establish one or the state government establish, or strictly stands, it is the judicial magistrate of the first class and below judicial magistrate of the second class. There is no judicial magistrate of the third class, there is no assistant session judge, and there is no metropolitan magistrate. These three changes have been made. That means no metropolitan magistrate, no judicial magistrate of the third class, no assistant session judge. Now, also it comes up with the special executive magistrate, that is SP and above. Any SP and above officer in the district can be considered as a special executive magistrate. You know, police districts have been created giving the police superintendent of police the magisterial powers. Maybe on the same lines, to speed up the investigation and to lessen the dependency on the district magistrate, especially the executive magistrate, the special executive magistrate by the police have also been created and not to below the rank of SP. Now we may ask, since SP is holding the district, then obviously SP, maybe sometimes if the range DIG or in some states like Karnataka, where the range is looked after by the IG can also be made as a special executive magistrate if he is staying in the district. Next, Central government may appoint a public prosecutor for the Delhi High Court, because it is always a tug of war between the Lieutenant General and the Delhi Legislative Assembly, because the PPs, APPs, and even the pleaders are appointed by the state government. Now it is clear for Delhi, that is the central government is going to appoint. Now, earlier, if there is no PP or assistant PP or any PP in the particular rural district or something else, usually the practice was that the neighboring district or the neighboring court PP or whatever the judicial prosecuting officer present, he was looked after as an additional charge. Now, this is going on for length of a time, and state governments do not bother to appoint a particular officer, judicial prosecuting officer, that one. Now it is made that the district magistrate is required to give 14 days notice to the state government and making such an appointment. Now, also, director of prosecution. If you see many of the states, they not come up with directly the strict hierarchy of the director of prosecution. Of course, in Madhya Pradesh, DOP is headed by an IPS officer of 1989 branch, but it was not uniformly followed in all the states. Some states have a proper director of prosecution, but in CBI and NIA, yes, director of prosecution is there. Below that, there is DLA, there is ALA, there is senior PP, PP, and so on, because each CBI office is having their own set of judicial officers, and they have own set of judicial courts also. But it is not practiced uniformly in the states. That's why investigation means investigation plus prosecuting officer. So they made it that a director of prosecution has to be there. No. Kan phun phone bong nó có mò. Lâu thì suy xuống. Thôi để. Hey, till Allah tilak. Okay, sorry for the disturbance. So, director of prosecution will be there. So, these are the offices established by the state government. Now, what was the difference? Earlier, director of prosecution was there, then deputy director of prosecution was there. There was no assistant director of prosecution, but under section 18 and 19, now the deputy director of prosecution and the assistant director of prosecution will be appointed by the state government, along with section 28, where the director of prosecution is also appointed. Added to this one, now the eligibility condition is very strict, because as I told, in MP, an IPS officer is getting the director of prosecution. But unlike in the earlier acts, now it is made very clear that a person who has practicing as a sessions court judge or a person with 15 years of experience as a advocate can only be appointed as the director of prosecution, like that. So now it is more strict and hierarchical. Then what are the functions and powers? Director of prosecution can give the opinion only on appeals. I will repeat, appeals only on the cases of the offences which are punishable for more than 10 years. Like that, 7 to 10 years, it is the deputy director. Below 7 years, then assistant director of prosecution will give the opinions on filing the appeals on any particular matter or such that. Next, the powers of the magistrates even in the courts. Now, as I told, there is a district civil and sessions judge. Of course, they can give even a death sentence to be confirmed by the division bench of the High Court of the consent. Apart from that, now we have only judicial magistrates first class and judicial magistrate of the second class. Now, the judicial magistrate of first class can give the penalty from 10,000 rupees to 50,000, whereas the second class magistrate can give from 5,000 to then 10,000. Also, there is one BNS, reform that has been made, the concept of community service as one of the form of the punishment. There are 6 offences where the community service can be given. Hope it has been dealt with, like the public servant unlawful in trade, drunken person in creating nuisance in the public, abatement to suicide or attempt to commit suicide, and stolen property, less than 5,000 rupees, first time offender, defamation. So these are some of the 5 cases where community service can be given as a form of punishment. To be straightforward, community service is not only the one punishment that has been. The earlier punishment is also for these 6 offences. Apart from that one, community service can also be given. It is not that is the exclusive punishment. Apart from the earlier imprisonment and the fine, another option is the giving the community service for these 6 offences. So both judicial magistrate of first class and the second class can give community service as a form of punishment. They are also entitled to give this community service as a punishment. Then Earlier, when the magistrates are writing the order, they were not deliberately to ask whether the sentences, if there are more than one offenses, then to write whether consecutive or consecutive. Now, specifically whether punishments will run concurrently or consecutively. Next, in case of an offense where it is less than 3 years and the accused is above 60 years or accused is infirm. Infirm means they are mentally and physically not so strong. In that case, the officer who is arresting has to take the permission of at least an officer of the rank of deputy superintendent of police. So this is the view that illegal arrests or wrongful detentions can be checked. This is what the law aims to find. Am I audible?
Yes, yes, sir. Very much audible. Very much audible.
Then there shall be another thing. This has come from the DK Basu versus State of West Bengal. There it says the grounds of arrest has to be made to the accused. Also, an information has to be given to the friend or to the relative of the accused about the arrests that has been made. For example, if if a person belonging to Bhopal has been arrested from Delhi, now even though for some issue or them from Delhi there is no network or they could not contact establishment with the relatives or the friends of the accused arrested person, then it would have been very dilemma for the parents or the dependents where that person has been missing. So for that purpose, now the law is clear that an officer of rank of assistant sub-inspector should be there in every district who give the public the information about the arrest, search and seizures that has been made. And for clear, you have to clearly visibly the names and addresses, the charges that has been against arrested persons. Now it can be, it has to be clearly told to the public. Of course, it can be done through the digital means. Digital means what? There is an SP office website will be there from there also. Because DK Basu versus State of West Bengal, it says there should be a police controlled room. Added to that, now two changes have been made. You can make it digitally information available. Second thing, an assistant sub-inspector rank officer should be there. There was no such thing even in DK Basu case that a what rank officer should be there. Only it says that you have to tell to the relatives of the police it was there. Then, when obviously as per law, three persons can cause arrest. One is the police officer if there is a cognizable offense that has been made out in front of him, in presence of him. Second thing, the magistrate can also arrest a person, accused person. Third, even the responsible citizen, even the civilian person can also make an arrest. But the earlier law was that 24 hours, excluding the time taken for journey, you have to produce him before the magistrate. Often, if a private person makes the cause the arrest, it may lead to some of the illegal detentions or putting the person beyond the required time. For example, if I arrest a person from Bhopal, although the police station is nearby, there are chances that I may put him in under illegal detention in my house or wrongful confinement to settle the scores against him and then taking to the police station. This might have happened in maybe happened, especially in arrests. So now it is clear if a private person is arresting any person within 6 hours and that too excluding the time taken for journey, he has to produce even before a police officer present or with the nearest police station. Specific provision for handcuff. Now earlier there are some lot of court cases what were fought, even on the issue of handcuffs. Because Article 19(1)(a), right to freedom of speech and expression, Article 20(21), right to life and liberty. Now even the defense side always argue that he is only an accused, he is only arrested on suspicion. Now you are handcuffing. What happens to his man, Sanman in the eyes of society? Why you are handcuffing is that is encroaching on his liberty. These all things were fought. For that matter, even in the parliament attack case, some lawyers approached the court that the police has to take the permission from the court for handcuffing the accused, even in parliament attack case. That's why the earlier laws, the CRPC, IPC, I am of the opinion, and maybe the opinion of you all people, they are more accused oriented. Whereas these laws, the new laws are citizen oriented, they are community oriented, they are victim oriented. Now it is clearly stated that the in the heinous offences, especially in the repeat cases, or the person who has escaped from the police custody earlier can be handcuffed. Here also it says only on the repeat of the offence or the person who has escaped from the earlier police custody. Escaped from the earlier custody means earlier he has done some wrongful work. That's why the police might have tried to arrest him, or from the police lawful custody he might have this one. Even today it has been known that only in the repetition of the offense he can be handcuffed, like organized crime, terrorist act, drug related crime, illegal possession of arms, ammunition, murder, rape, sexual offenses, children, acid attack, counterfeiting of coins and currency notes, human trafficking, offenses against the state. These are the areas where the accused can be handcuffed, provided if it is a repeated offense. Then immediate seizure of offensive weapon after the arrest is made. That is also a very good this one, because most of the times seizure weapon is made at the otherwise not on the when the arrest has been made. Without any delay, the registered medical practitioner. Always the law considers registered medical practitioner. They don't consider the word doctor, because RMP is registered in a particular state. So without delay, it has to be sent to the RMP has to send the medical examination report. Of course, the additional medical examination can also be conducted as per the BNS. Another thing that has been there, is that earlier, only the sub-inspector and above officer can request for the medical examination. Now, as per the Police Act, even the police constable is a police officer. Now, there is no such bar who has to request for the police medical examination of the accused or whoever it may be. Now, anybody can ask from the police side. Then technology, now you can file the summons, you can send the summons through electronically. For example, you can send it by WhatsApp, official channels, official Telegram channel, official WhatsApp channel, official emails, and all those things. But the thing is that it has to properly bear the court seal and the digital signature. Okay, not only the service of summons, even for you can file the FIR, EFIR, you can have 0 FIR, you can file the police report 173 earlier, now it is 183 of the BNSS. You can file the police report under this one. You can take a search warrant, warrant of arrest, everything on e-copy. Everything can be made as e-compatibility, this one. Next, gender neutrality. Earlier, the summons can be issued only male member of the family, adult male member of the family. That means above 18 years of age, should be male, and he should come under the definition of the family. Because considering burqa women, parda nishan women, some communities like in Rajasthan, women don't want to come outside, and even if it is felt that police coming and serving something chitti to the women means it was viewed very wrongly in the villages and all those things. That's why the women don't usually appear before the police or whatever it may be. Now they have considered that yes, it is the adult member of the family. Any adult member of the family can be served the summons. Next, cause the duty of making arrest for yes, if you are making an arrest in this one, regarding such arrest, you have to give the arrest person held designated police officer, and to such police officer another district where the arrested person normally resides. For example, territorial, beyond the territorial jurisdiction of your jurisdiction, you are arresting some person. Obviously, there is an ASI in that district. You have to give the information to that ASI and also to the police station, police place, police station where you are making the arrest to give the information. Next, proclaimed offender. Earlier, only some of the heinous crimes where the offender can be declared as proclaimed offender, like rape, trafficking, etc. But now, as per section 84(4) of the BNSS, now it has been broadened. Any offense where the imprisonment is more than 10 years, now in all those cases, a provision for proclaimed offender can be declared. Added to that, now in BNS, there are more than 100 offenses where it attracts more than 10 years of imprisonment for life. So the punishments have also been enhanced. Next, earlier what happened, the person comes to the police station to register a complaint. The police does not register, then he used to go to SDPO, additional SP, or to the SP, or even to the Commissioner of Police, and all those things. Now it says, go to the police station. If not registered, SP, even the intervention of SP, the complaint could not be registered, then take an affidavit, make an affidavit that they have approached first the police station and the SP, and then go to the magistrate. Then the magistrate can cause investigation through himself or by the police. This is one citizen centric for the registration of the FIR, because registration of the FIR is one of the major problem even in the police station, and there is always a complaint that police does not register all the cases. Of course, the Lalita Kumari case is there. You can register a preliminary inquiry, but for that also you have to consider within 14 days. Within 14 days, you have to submit the preliminary inquiry report. Then videography of the search and seizure, very important. See, when we go for search, first search warrant is there, grounds of search is there. We have to put the reasons for ground for belief of making the search. Also, we forget that we have to offer body search for the inmates of the house, so that we do not have a plan to initiate any of the implanting of the evidence. That's how a lot of allegations have come against the police, that the police have implanted the evidence. So first, when you go for search, when you show the search warrant and you explain the reason for search, then first is that you offer yourself a body search, so that allegations does not come. And added to that, now the compulsory videography of the whole search and the season now took place. This videography should contain at least two things very importantly. One is that the signing of the independent witness, number one. Number two, the preparation of the Caesar memo itself. Why? Because, see, independent witness, you might see in most of the cases, there are prominent repeated independent witness. To be frankly, in some of the cases, the police station sides adjacent to police station who is a chai wala, who is a shopkeeper or who, they are usual witnesses. There are temporary witnesses. We call it as regular police witnesses, because witnesses does not come for the police. That is one of the thing, and that's why we always say like these kind of things. Now it says that the independent witness signature has to be right. And second most important, now we always take whatever in the search and seizure place, come to the police station. There we selectively choose what are the documents to be seized. Then we fill the seizure menu at our leisure. Then we forward it to the court. This raises a lot of procedural lapses. Now it says compulsory videography, which includes signature of the independent witness and also preparation of the seizure memo. Also, within 48 hours of conducting the search and seizure, you have to produce the seizure memo to the jurisdictional court. Now the question is whether the videography is a part of final report under section 173 or the 183 of the BNS. Yes. If you see now, whatever the videography, maybe 10 hours, 12 hours, 15 hours, you made a videography, that will become a part of final report. You have to send a copy to the court. Also, you have to give a copy of the videography even to all the accused. Now, if you do not conduct a search and seizure very properly, it will be put it in the public domain by the accused side, and they will start commenting what are the mistakes that has been made. That is sufficient that the case may fall down. This is a very, very important challenge, especially for the police, to maintain the integrity and also maintain all the procedures to be intact while conducting the search and seizure. See, you have to maintain proper decency while conducting search and seizure. Secondly, there should be one person always accompany you of the house in conducting search and seizure. Thirdly, the order of the items that are being kept, this one, as far as practical, they should not be disturbed. That means you take item wise and keep it side by side, side by side. That means you cannot throw it as if this one. So the maintenance, decency, everything has to be maintained throughout the search. So there are so many provisions, especially in this one. There should be 165B, when a police officer, there is a simultaneous searches where he cannot go for only for all the places. Then you can depute his subordinate officers. So a lot of questions will come. Also, it says videography can be done even on mobile phone. Now the question is that when you are retracting the this one, this is considered as a primary document. You can retrieve the phone for videography from the mobile. Now what happens? For example, mobile phone, only 1 hour, 2 hour you can make a videography. Then you will come up with the other mobile phone. So that will part of the same exhibit, but as exhibit 2, that is a continual portion. Now you have to explain what is the time lapse between the two exhibits, why there was whether there was any deliberate selective recording of the police. This is a major challenge that may come up during the trial, especially regarding the search and the seizure. Next, to attach and forfeit the property obtained as proceeds of crime. See, as per as Prevention of Money Laundering and Act, see, ED, the proceeds of the crime has to be attached. But the problem was the lengthy, this one, especially when the accused went to the abroad. He went to the abroad, you issued a letter of regulatory with the local court, then you have to send it to the CBI, they will send it to the embassy, that embassy to our embassy, then it will send to be foreign embassy in that foreign country. From there it will go to the chief secretary or whatever may be the hierarchy there. By the time it go to the proper authority for investigation, that it takes years. That's why you have seen in the banking frauds case, even in CBI, letter are hardly been followed in letter and spirit. Now they made it very clear that even the superintendent of police can take the production from the permission of the court and ask for the forfeiture and forfeit of the property as far as this one. Thus simplifying the long process of leterogatory in this regard, especially the attachment of property. Now, maintenance of wives and children. You might say Article 20, sorry, Section 25 of the CRPC says about the maintenance of wives and property. Added to this, central government came up with one special acts stating that it is the duty of the sons, the age-old sons, majority sons, to look after the elderly parents, provided the elderly parents are not a part of dependent family. For example, if they are not pensioners, if they don't have sufficient property or sufficient amounts, resources to lead their life, obviously it is the duty of the children, that is the sons, to take care. Earlier, if the violation was there, the elderly parents has to put a petition in the place where the son is residing. They may be thousands of miles apart. Now it is made that the elderly parents can file a petition in the area where they are residing. Now, Deputy Commissioner of Police has been added in Section 162, who can deal with the case of public nuisance. Then, if there is a person who is resisting, refusing, or disregarding to the lawful bona fide orders of the police, then he can be detained. But the thing is that he has to be released within 24 hours. Because these are petty offences, they need not want a long detention and illegal arrest as such. Zero FIR has been introduced. Now, zero FIR, for example, you are in Bhopal and you are going to some other place. You cannot file a register in Bhopal and you go to some other place and you register a FIR either physically or through electronically. You registered a electronic FIR in, for example, if you go to Delhi, you registered an electronic in the Delhi police website. Now, the law says within 3 days, you go to any of the police station and give a signed complaint. It is not that you have to go to the jurisdictional police station only. Go to the any police station, apart from the earlier FIR that has been registered online, go to that one and give a signed complaint. Now the question is, why signed complaint? Obviously, a complaint should be there to prove that complaint has been received. Either it should be transferred or suo moto or registered by electronical means. Now this is electronical means. There should be a record on the court to prove the FIR copy. So for that's why within 3 days that person has to go to the police station and sign the complaint as such. If he has already registered through e-film, that is email or something else, take out the copy, signed it and give it to the political police station. That police station will transfer the case to the jurisdictional police station. Next, zero FIR, that already I told. Next, earlier DK Basu says the accused has entitled to get a free copy of FIR. Now it says victim. Victim can also, of course, the complainant may be different and the victim may also be maybe different. Then, if there is a case which is less than offense punishment less than 3 years, 3 years, but more than 3 years, but less than 7 years, and the IO or the police station in charge don't want to register the case before verifying the facts or something else. Earlier, this concept was there, that is preliminary inquiry. Of course, Lalita Kumari judgment also says that if there is a cognizable offense, then no question, you have to register the case. But if the contents are such vague, if the contents are such that you cannot make the exact whether cog, non-cog or the offense, or you need some time to find the veracity, the truth or the genuineness of the complaint itself or the complainant itself, then you can take some time to you can conduct a preliminary inquiry. But the time period was not prescribed, although it was said that 15 days you should have to preliminary inquiry. So they used to file a PA and stating that when the complainant come and ask the police station, they told that we have registered a PA. But there was nothing that was moving in the police station. Now, seeing to that one, now they stipulated a timeline of 14 days. The preliminary inquiry has to be disposed of. Next, making an application to the magistrate is entered, FIR is not registered even after the intervention of the superintendent of police. That is already dealt with. Credibility of investigation, non-cog offences, officer apart from referring to the complaint also forward the diary to. For example, he registered a non-cognizable case. Now law says that 15 days once you have to send the case diary to the court because non-cog offences are less heinous crimes. It is not that you register a non-cog case and keep harassing the accused. That's why it says that what is the progress of the non-cog offences cases, you submit at least once in 15 days. Then gravity of the offense, SP can depute even a DSP to conduct the investigation because earlier there were some cases like dowry death under 304B read with 498A, SCST Act, and so many acts where offences where a minimum level of officer like DSP was stipulated to register to investigate the case. Now it is up to the SP, especially in BNS cases, to depute DSP rank officer to conduct the investigation if the crime is such a heinous heinous case. Now magistrate, before directing an investigation by the police, requires to examine the application of the complaint along with the affidavit submission made by the police officer. The magistrate may inquiries in this regard. That is there. Then against public servants, see, when we are carry forward our official bona fide duties, there are a lot of complaints that comes against the police officers itself. There may be frivolous or they may be having no grounds at all, but still to harass us, many people will complain against the police officers itself. FIRs or register. These were actually happened as far as I saw, especially in two instances. One is the encounters. Second thing is that whether the police have overact in the name of self-defense. This is the one thing. So whether it was a government duty, whether it was they breached the law, they took the law in their own hands, only the circumstances may tell. Now, what circumstances make me to take such action? Earlier, what happened is that because earlier was accused centric and quite against the police, सीधा सीधा FIR लागू होते थे. So now they made it that if there is a complaint against the police officer, you ask a report from a senior officer. For example, DIG हो गया तो IGP. Usually they will not ask from the IG. They will ask the court will directly ask the DGP. DGP will send it to my senior, and they will send my senior will submit a report regarding that incident. And also opportunity to given to the police officer under what circumstances he has to act like that. See, discharge of official duties, anything can happen. You need to take a decision in a split second. So now it may not be legal every time. Your judgment may be wrong. For that, you straight away go to the FIR. Then nobody will take that kind of a that conviction to bona fide even a lawful duty also. Always we are under the fear. ओ ऐसे हो गया तो ऐसे क्या करेगा, मेरा ऊपर में ये FIR हो जाएगा, मेरा ऊपर में ये गलत आरोप आ जाएगा, इसीलिए मैं बहुत थोड़ा सा क्लाउड में रहते हैं. I will not go into the extent. These and all those things because fearing disciplinary inquiry, FIR and all those things. This is a very good step for the police officers, especially to discharge our official duties without fear and anything fear or favor. Now, rape. In cases of rape, the lady magistrate has to conduct the trial as far as possible. If not available, the gent magistrate, of course, in the presence of women. Earlier, it was for the arresting of a woman. We need a presence of woman constable or like that. Even to interrogate a woman person, even accused also, we need the presence of a woman officer like that. It was there. Now it is applicable to even to judiciary and this one, especially in rape cases, it has to be by the lady magistrate as far as possible. Next. Now, to the forensic team to visit in all the cases to the scene of crime when the offense is punishable for 7 years or more. See, the forensic is very reliable, this one, and to bring credibility to the investigation because there are a lot of lapses in collection and recording and transporting and maintenance of the forensic this one. Mainly one of the thing is that how to collect, especially in the cyber crimes, when the mobile phone is switched off and the laptop is switched on, switched off, and how to collect the RAM data, how to use the write blocker, SSD drive, hard drives, all those things. And even in other cases also, blood sample, उठाने के समय, they don't usually pack it correctly, they don't use it collect properly. So that leads to a lot of integrity issues, chain of custody issues. A lot of there was there, especially the collection of the forensic evidence. Now it is stated that whenever there is a heinous crime and the to an offense which is punishable for more than 7 years, a team of forensic has to be taken. Now, all the districts in the country are not having these facilities. So it says that now you take the nearest police station or the nearest state also, in fact, to take the help of the forensic. And it also made it now within 5 years. Within 5 years, just hold on. इसको ये डाल दीजिए. Hey, put this one wherever it is there. So, sorry for that one. Now, the state government within 5 years has to make. Already, the Minister of Home Affairs has made it compulsory that there should be a mobile forensic van that has been practiced in Karnataka, and there is a proper this one. But even in northeastern states, even many of the police stations are just given with one forensic kit. Apart from that, not much advancements have been made in this regard.
वो दोनों का शिवानी दोनों का सेम प्रोसेस है, तो वो शिवानी स्टार्ट कर रही है, ठीक है। उसके बाद जहाँ कुछ इश्यू होगा तो मैं ये फोरेंसिक वाला लास्ट में थोड़ा सा रख
We will be joining shortly after 5 minutes. Kindly stay connected.
Am I audible? Am I audible?
Yes.
Okay. My PPT is also coming?
Yes.
Okay. Sorry for this one. Yeah, 7 years and above any crime. Now it is stated that you have to take the forensic this one. Now what happens is that you take forensic experts also, the collection, packing and evidence and preservation will be more scientifically this one, and also the scientific evidence, because it is often said that the men may lie but circumstances may not lie. So this is also a good step, but the problem is the logistic facilities available, especially with regarding to forensic science. We have the SFSLs, we have the MATI under this one elites and all, and also the CFSLs. But still, the forensic logistics has to be this one, and the experts also need to be increased more to implement this one. So anyway, the government has given 5 year window to come up with a proper forensic logistics in each and every state. Next. Section 179 of the BNSS also exempts some of the persons like women above 60 years of age and person with acute illness. But if they want to come to the police station to give record their statement, then it is okay. Otherwise, they can give their statement from wherever they are. That is why section there is audio, video, electronic means. Now another thing is confession statement. Earlier section 164, now it is 183 of the BNSS. Earlier only the jurisdictional magistrate can only take on the confession statement. Now whether they have jurisdiction or not, he is made competent to record the confession or the statement in the course of even investigation also. Then heinous offences in section 183, punishable with 10 years or more or with or nil, and even during the investigation, when the case is such an heinous offense where it attracts 10 years or more life imprisonment or death or whatever it may be, about 10 years of this one, the magistrate is to record the statement of the witness. Then protection to the victims of rape. It has been stated that statement shall be only recorded by the lady magistrate as far as possible. It is not mandatory only the lady magistrate. Of course, in every district, lady magistrate may not be available, but as far as possible, if only a gent magistrate is there, then the presence of women is required. Then speedy accountable criminal proceedings, forensic expert of the, especially with the forensic report of the rape victims. Now it has to be forwarded within 7 days. So that's why the medical reports, these are very sensitive cases, especially against the women and the children. That's why all the cases, all the offenses against women and children have been get into one place and made it as chapter 5 in the BNS. And section 185 introduces several checks in the police while conducting search. First, obviously, he has to put in record the grounds of his belief for conducting search and place. Second thing is that he has to put it in case diary, and also search conducted by a police officer has to be on the audio, video, electronic means he has to record this one. And more on top of that, after the search has been made, the seizure memo has to be sent within 48 hours. because often we tend to prepare the Caesar memo in the police station, call the independent witness there only, get their signatures. Now it is not possible because videography has to be done, and search Caesar memo has to be done in the place of the place searched now, and also after the search within 48 hours you have to send that report to the magistrate, concerned magistrate empowered to take cognizance of that case. Then initial 15 days. Now the police custody, very important for the police officers. See, the police custody is still remain the same of 15 days. Now what has changed is that earlier 15 days police custody can be taken within the first 15 days of presenting the accused before the magistrate. For example, if he has arrested on March 1st, then whether you take or not take, on March 15th, the police custody should be over. Now they made it, the police custody period remains the same 15 days, but you can take that 15 days in the first initial 40 days of arresting that person if the case is to be investigated in 60 days. The police custody of 15 days can be taken within first 60 days, either in part or in a whole, within 90 days if the case within 60 days for the cases which has to be investigated within 90 days. Now the thing is that you can arrest him again, if he has released, then you can again really arrest him, and all those things 40 days. That means you can take it in a whole or in a part. In the first 40 days for a cases to be investigated in 60 days, for the cases to be investigated in 90 days, that 15-day period is available within first 60 days. Now the question is that, now what happens if the case goes to CBI or NIA? For example, section 113 of the Bharatiya Nyaya Samhita tells about the Terrorist Act. This is the almost a cut and paste copy of the section 15 of the UAPA Act, Unlawful Assemblies Prohibition Act. Now, the SP has powers to register a terrorist act either under section 113 Terrorist Act as per Bharatiya Nyaya Samhita or section 15 of the UAPA Act. In Bharatiya Nyaya Samhita, the police custody is 15 days only, even for the Terrorist Act, section 130. But in the UAPA Act, the police custody is 30 days. I will repeat, 30 days. 30 days is there. Now, if the SP register a case under BNS and he has taken a police custody of 15 days, of within the time period of 90 days, either in whole or whatever it may be. Now the case go to the NIA, or for that matter, if it goes to the CBI in any other case. Now whether CBI or the NIA can take fresh 15 days or the fresh 30 days, whatever it may be. Now the answer is on paper, yes, because CBI or the NIA re-registers the case. It doesn't move forward with the same FIR that has been registered by the state police. Since they re-register the case, they have the fresh, they can take the fresh of 15 days custody of the accused. This is the very important thing, because एक गलत अफवाह चल रहा है देश में that अभी 90 days, 180 days, 60 days, 40 days तक पुलिस उनको कस्टडी में ले सकते हैं. नहीं, गलत है. 15 days remain the same. Only thing is that initial 40 days में ले सकते हैं, either in whole or in parts, even in 60 days for a cases to be investigated in 60 days. This is the thing. Then under section 87 says that detention shall be made only in the police station or the place wherever it is there. This, of course, to prevent illegal custodies or wrongful confinements. Then who was not in custody was mandatorily arrested, produced in the court for the magistrate to take the cognizance in of the charge sheet, especially when the framing of the charges and when hearing of the judgment. The presence of the accused was must in the earlier cases, but now it is changed. Now has been changed. Condition of accused being in custody. Now it is take a sufficient surety, shall take security for his appearance before the magistrate, and the magistrate need not refuse to accept the charge sheet just on the basis that accused is not taken into custody. Next, officer in charge of the police station, including electronic means forwarding the police report. Now earlier section 173 police report. See, there is not such that the charge sheet. Police report may end up with charge sheet, may end up with closure report, or may end up with transfer of the case. These are the three possibilities. Now, but usually what we say is it is a charge sheet. No, charge sheet is a form of police report. Similarly, closure report is also a form of police report. Whatever it may be, now you can produce through e-means. Why it? Because, for example, in the like Mumbai blast case and all those cases, the charge sheet was running into thousands of pages. That was put it in huge trunk boxes because it contains all the witness statements and all those things. This one. So that's why they made it that now you can file the police report even in e form. That is, you take it in a pen drive, give it to them, and give it to the court Peshkar or where the committal has to be taken place, where the cases police reports are usually accepted in the particular jurisdictional court. This one. Now it helps the police to what it helps means see multiple copies. Even also that police report copy, it has to be given to all the accused. Now you give it in a hard drive or a pen drive. Now the question comes, what if the police has given that later he referred that one I have not received? You can take a receipt copy in a blank paper or whatever it may be that I have received a such and such. Then second question is what happens if he opens the pen drive or the hard drive and nothing find out or something else find out? So these are all the questions that will come into the court, that they were not proper, all the materials were not put in the this one. That's why, the law says actually it is the magistrate who has to who has to serve all the copies to the accused. But in practical, it is not like that. In practical terms, it is the police who gives the copies, that is the charge sheet or the final report copies, to the advocate of the accused, because the accused may be UTP, he may be languishing in the jail. Anyway, now the thing is that you can file the charge sheet and you can give the charge sheet copies to the accused in the e-form also, in the electronic form also. Next, in cases earlier, what about the victim? Accused centric, now they made it. Victim has the right to know the progress of the investigation within 90 days. So within 90 days, police has to inform what is the progress of the investigation to the victim. Of course, they can inform even through the digital means. Now the question comes, for example, today I register a FIR, after 2-3 days, just I inform the victim that I have registered a FIR, investigation is progress. Can I wash out my hands that I already informed the victim about the progress of the case? Yes, in a way, yes, practically this one for all theoretical purpose. But here the progress of the case means substantial progress that has been made in the police. It is not that FIR been registered, I inform the same to the accused. Next, sorry, victim. Supplying the police report and other documents was this one. Now it says, yes, it is the magistrate who has to serve all the copies to the accused, and that too within 14 days. Within 14 days from the date of production of appearance of the accused. So all the copies has to be supplied documents through electronic communication. 230, this has been further streamlined. Magistrate has supplied the documents so received to the accused within 14 days from the date of production or appearance of the accused. Technologically compatible by including supply through electronic this one. Now during trial, after filing of charge sheet, further investigation required, it shall be completed within 90 days, and any extension of time period beyond 90 days only with the permission of the court. See, 60 days and 90 days is there. In UAP Act, it is the 90 days plus 90 days. But even in UAP Act, it is not that the 90th day is closing and I will go to the court and ask for the further 90 days. It doesn't happen like that. Maybe by 80th day or 82nd day, you have to approach the court, sir. It is presumed that within 90 days I cannot complete the investigation. You please give another 30 days. It is as good as like in the requesting for the police custody. 15 days, all of a sudden you cannot ask. Even if you ask, the court is not going to grant. Why you need 15 days? Moreover, it is on terms of hours. It is not on days, because you have arrested him at morning 2 a.m. So that's why it runs into hours. Similarly, here also 90 days. After 90 days, 90 days is possible, but only in part by part. You cannot go that once for all 90 days. Of course, there is no mistake in asking, but the courts usually don't entertain in this one. That is especially with the UAP Acts. But in actual thing also, as per the earlier CRPC also, you are taking more time rather than 60 days and 90 days. You have to seek the permission of the magistrate to go for further investigation or to continue with the case. But usually police officers do not take the permission even if they cross 60 days or 90 days. That is one of the this one. But now it is made very this one. After you crossing 90 days, you have to compulsorily take the permission of the court to continue with the case, so that the unnecessary delay is prevented. Next, for forwarding, for example, suicide happened in the district. Within 24 hours, you have to send a report to the magistrate. Why? Why? Because it may be suicide or murder, and magistrate should has to know what has happened, especially the suicide or murders has been happened, so that suicide cannot be written as murder, or murder cannot be written as suicide, as some of the times it happen. Next, it says no male person under the age of 15 years, above 60 years, a woman mentally or physically challenged, or a person with acute shall be required to attend any place other than a place in which such male person, woman reside. So, but if they are willing to come to the police station, they can go. Otherwise, where they are residing, there only the recording of the statement has to be taken place. Of course, establishment of the commission is by the court, that is during the trial. That should not be confused with the recording the witness statement, especially during the investigation. Next, offense committed outside India. Then what happens in case of evidence relating to offense committed outside India? The position may be produced in electronic form only. For example, if it has happened outside, for example, Dubai, Sri Devi's murder, death happened. If they want to send it a report, means they can send it by electronic means. I am just giving the just an example for that one. Now, cognizance of the magistrates on police report includes submission of police report. I already told by e-means also you can this one. Now, prosecution sanction, very important. Now, up to maximum of 120 days, you can delay of giving your opinion on prosecution sanction. If 120 days you give, yes, no problem. Even if you reject the prosecution sanction, no problem. 120 days you took the decision. But if you just sit on the file without giving yes or no on the prosecution sanction, then after 120 days, it is deemed to have been given the prosecution sanction. So, my dear officers, so now the protective blank around us, that okay, I have done the mistake, I will manage with my department of not giving the prosecution sanction, hence the trial will not start, will not go any good in the coming days. After 120 days, the trial will start and it deemed to have been given. Maybe the court may also even start even pending prosecution sanction, because they know anyway, they know within 120 days, if it not doesn't come also, it deemed to have been come according to. Next, complaint cases, even without the knowledge of the accused person. Without the knowledge of the accused person, the court take cognizance of offense even without the knowledge of the accused. To strengthen the rights of citizens, that the magistrate shall grant an opportunity to the accused person to present his side of the court before proceeding. Especially this is in the cognizance in the complaint cases. Again, in complaint cases, protection against false and fraudulent cases against public servants. This is only in the complaint cases, not in the warrants cases. Complaint cases, now what happens is that now they need to take submissions from my senior officer, what has happened, and also give an opportunity for me to also explain my situation, how the wrongdoings might have been happened. Next, issue of process warrants may also be issued through electronic means. Other documents for accused victim is to be made within 4 days from the date of, this is 14 days. Supply of copy of the police report, that I already stated through electronic means we can give. Delay in commitment of the cases, now this is very important. Committal of the case. Within 90 days from the date of magistrate take the cognizance, committal has to be taken. This period may be extended to 180 days with reasons to be rated, because many cases committal of the case does not happen. Now the maximum period is 90 days with extendable to 180 days with reasons to be written in this one. And also for discharge application, now the maximum period is 60 days. Why? Why? Because if there are 4 accused, first A will go to the court and ask for the discharge petition. Then if it is set aside, then he has an option either to go to the sessions court or under 482 inherent powers of the High Court to file a petition. Then the way is ended with this opportunity, then B starts, then C starts, then D starts. For years together, they just delay even the even the start of the trial. Now it is clear, within 60 days from the date of committal of the case, the filing of the discharge petition has to be over. So that is also there. And also 16 days timeline from framing the charges from first hearing on charge. You frame the charges from that first hearing on charge, within 60 days you have to frame the charges. That is also. So 60 days for framing of the charges, first hearing, 60 days for committal of the case, discharge of the discharge of application, after committal of the case, and committal has to be taken within 90 days, extendable to 180 days. See, there are 35 timelines in the Bharatiya Nagarik Suraksha Samhita, so that the trial proceedings will go very smoothly and without any adjournments or delays. And also, deposition of evidence. Yes, public servants, this one email is there, electronic means is there, that need not be again discussed. Then judgment has to be given within 30 days after the last date of hearing. Of course, extendable to 45 days with reasons to be recorded. See, reasons to be recorded in writing, now it comes even to the magistrates also. Earlier, there was no provision as to why the magistrate has to write the reasons for. Earlier, there was reasons for police officers to return. You are arresting a person for a non-cognizable offense. What were there? But now it has leaked down to the magistrates also. The idea is for the speedy trial. Justice could not be delayed or denied also. So they want a speedy trial in that case. So within 30 days after the last date of hearing, extendable to 45 days with reasons to be written by the magistrate, the judgment has to be given. And judgment has to be uploaded within 7 days. Usually hota hai. Usually in this technological issues, they upload the judgment 7 days or 10 days. But in some courts like family courts, they still take time. They don't upload this one. Of course, it is the court registrar, Peshkar, and who has to blame. Recently, even Supreme Court has come harshly on its own employees for not uploading the judgment or giving the copies as such. Next, filing discharge application has been prescribed 90 days from the date of supply of documents. Similarly, that the charges must be framed within 60 days from the first hearing. Next, the examination of witness is allowed to be done through audio video, that already seen that one. Shall be deemed that such witness shall not be examined for not being available, so that magistrate may lose the prosecution. See, for example, sometimes the witnesses cannot be made secure despite giving opportunity, and even all reasonable measures are given. For example, some security forces, while they were performing a duty, they put a case, but later they get transferred, then it is very difficult to trace them out. So now the magistrate may lose the prosecution evidence and proceed with the case on the material basis on record. Next, also in the complaint case, where it is less heinous crimes, complainant remains absent even after giving 30 days notice. Sometimes to settle the scores, just they file a complaint case and they do not appear for the hearing. In those cases, there is no need to harass the accused. That's why law says that even giving 30 days time, if the complainant does not case, especially in the complaint cases, then it is considered as okay, over, and the magistrate can close the case. Then plea bargaining within 60 days of framing the charges. After the framing of the charges, within 60 days, the plea bargaining petition has to be filed. Of course, plea bargaining is not a success story in India, because they are tutored. They always think that they can get out of the law, because if you got into plea bargaining or mutually satisfactory disposition, then minimum punishment will be there. And also a time period for 60 days for mutually satisfactory disposition, where the prosecution, defense, and the accused and the victim, they all come to one conclusion to mutually satisfy and dispose of the case. This one also for the first time offenders, where the minimum punishment is prescribed, court may impose a sentence equal to 1/4 of the minimum punishment. Okay, earlier it was 1/4, and for the where there is no minimum punishment is correct, then it is 1/6 of the minimum punishment, and from the previous 1/4. So what happens is that is more progressive and rehabilitative lenient in plea bargaining cases. Adopts a plea bargaining case. So if the accused plea bargains, then 1/4 where the minimum punishment is there, where there is no minimum punishment, and 1/6 award punishment can be awarded. Then enhance the technology examination through audio video. Already we see this one. Yes, obtained the signature of accused who undergoes examination video conferencing must be obtained within a time frame of 72 hours. Okay, under trial prisoner, he appeared from the jail itself, but however for the court records he need to be signed. So after within 72 hours he come physically and sign the statement that has been he has given, maintaining procedural integrity through timely documentation. Then relax at the discretion of the court, challenge the genuineness of the any document. See, any document, if it is challenged, then only it can be taken. If it is not disputed, then the court may need not to consider. For example, the forensic report. Now it is under section 39 of the Bharatiya Sakshi Adhiniyam. If it is not disputed, again, no need to call the forensic expert. That's what this one says. Officer, another thing. For example, a public servant is there. He has to be present before the court. but he cannot be secured. He may be died, he might be in the bed, dead bed, he cannot listen, he cannot see, he cannot untraceable. In that case, the new law says that the successor in the office can come and give the evidence. For example, signature, he can say that, sir, I have gone to the other documents, his signature is found to be his only, like that he can tell. Then framework court consider objections of may grant not more than 2 adjournments. See, this is the one that the lawyers are litigating. Now, due to the adjournments, too many adjournments taken in the court, the delay in the proceedings happen. Now it says beyond the control of the litigant, not more than 2 adjournments can be made. Of course, reasonable reasons has to be given, but it says uh, for reasons to be in recording, only 2 adjournments can be there. Beyond that one, reasons has to be recorded. As far as now, it is simple. The defense can only take 2 adjournments. If more than 2 adjournments, then they have to give sufficient reasons on this one. Next. Am I audible?
Yes, sir.
PPT is also coming. PPT is coming.
डिस्कनेक्ट हो गए सर
हाँ, डिस्कनेक्ट हो गया. डिस्कनेक्ट हो गया. Now it is seen. PPT is seen. Okay. Okay. Specimens or samples without necessitating their arrest. So without arresting the accused, now you can take the specimens or the samples, voice samples or what. So is the PPT is sharing? Next, fugitive criminals, proclaimed offenders. Now it is said that the process involves issuance of a Shankar, I will call you after some time. I am in midst of VC. I am in VC. I will call you after some time. Framework damages. Okay. Proclaimed offenders, issuance of warrants of arrest within an interval of 30 days. So notices has to be given in the local newspapers, and notification, and the relatives and the friends, relatives has to be informed about the trial to be started. The trial of proclaimed offender only commences after passage of 90 days from date of framing of the charges. So this is also there. See, another thing is that when a proclaimed offender joined the investigation, of course, he has submitted a charge sheet, proclaimed offender charge sheet he has submitted. Now he has the right that he can, as per the whatever the earlier witnesses that has been presented in that this one witnesses during his trial in absentia. So this says even if the proclaimed offender does not join the trial, now the trial will continue. Earlier, what happened? A and B are there. B is a proclaimed offender. They used to be a split of the case. There may be a separate CC number, and they go ahead with the A. But if the material is such that it is enough to induct even B also, even if he is proclaimed offender, now the absence in trial in absence. This also continues up to the judgment. Even in his absence, the trial has to be ended or the judgment can be given. However, he joins the proceeding mid-trial. he is entitled to participate and benefit from due process. That means he can ask for the earlier testimonials that has been made in that court. That's what it says. More victim-centric approach, it has stated that withdrawal of the prosecution. See, earlier, see, one political party came, it registers some cases. Next political party cases, it withdraws the cases. Now, what happens to the victim? Who will hear to the victim? Now, it is said that you cannot withdraw any case from prosecution without hearing the victim. That's why it is more of a victim-centric this one. Then accused may be produced through audio, video means of. Another thing, witness protection scheme. See, this is the one thing that many of the law commissions repeatedly selling.
evening,
Why?
sir.
Tell me, madam. Am I audible?
सर आपकी वॉइस नहीं आ रही है सर. You are not audible, sir.
ओहो. मैडम अभी सुन पा रहे हैं?
वॉइस नहीं आ रही है सर.
अभी? अभी नहीं आ रहा है मैडम. Is it now coming? Is it now coming? Am I audible, please? Hello? Madam, am I audible?
Very much audible, sir.
Okay. PPT also coming? Yes, now?
Yes, it's
Please.
visible.
Visible. Okay. Audible also. Okay. See, even the Malimat committee also insisted on the witness protection scheme. See, compensation to the victim, it is already there. In the IPC, of course, now the BNS, in the rape victims, section 63, or even the gang rape, now it says under section 72 of the new BNS, Bharatiya Nyaya Samhita. Parvez? Voice अभी आ रहे हैं ऐसे सुना. Voice is coming, I think. Am I audible? No. Shall I finish now? Okay. Close कर लीजिए. There is technical glitch also. Thank you, participants. Thank you. There was some technical glitches. Sorry, I could not complete. Okay. Okay. Close कर लीजिए. Thank you. Okay. Right. Right. Not audible.
Yeah. 50. Two. 32.
ये निकाल दूं?
हाँ, निकाल
नहीं ऑनलाइन शेयर करने के लिए चाहिए
इसी सिस्टम पे
नहीं
ड्राइव कर दे
ये पोर्टल ये आईडी
उसको पढ़ देते हैं इसका हम्म? 50-31
कोड को इसको क्या चेंज करेगा सेम सर पुलिस को कौन सा डेटा चाहिए स्टेटस है यहाँ पे 6 है और अभी यहाँ पर केवल इसको क्या दे दिए सीसीटीवी ये जो डेटा है ये यूजर का पोर्शन है या इसी जिसका ये फॉरेंसिक कौन कौन क्या के सिंपल मैं सभी रहा है बात कोड करना उनके application में
चार उसमें
को एंट्री नहीं करनी पड़ती है
चेक कर कैप्चर की
FIR नंबर को और फिर तीन एप्लीकेशन ऑप्शन वो जो भी सिलेक्टेड क्वेरी किसी मतलब देखो के एप्लीकेशन में भी CCTMS में एंटर
स्टिल नहीं उठ रहा।
तो और हमारी लेकिन उसकी आईडी
मैं सर डायरेक्ट ही ऐसी बात चला रखा है।
नहीं ये लिंक की
ये चला दूं PDF वाला या तो डायरेक्ट भी दिखा सकते हैं, यही ना? डैशबोर्ड दिखाने का सर? About प्रोसिक्यूशन का डेटा देख पाएंगे। केस टाइमलाइन में जाएंगे तो ये केस कब रजिस्टर्ड हुआ, प्रिजनर का कब एडमिशन हुआ, कब एफएसएल केस रजिस्टर्ड हुआ, कब चार्जशीट हुई, कब एफएसएल रिपोर्ट रेडी हुआ, कब प्रिजनर रिलीज हुआ, प्रिजनर का एडमिशन कब हुआ, ई प्रोसिक्यूशन की जो रिक्वेस्ट है वो किस डेट पर रिक्वेस्ट हुई। तो आपको ये पूरा एक जगह पर जो डेटा है पूरा मिल जाएगा। इसलिए आप सबसे पहले जाके अपना जो है इस केस का आईडी क्रिएट करवा लीजिए। और वो क्रॉस वेरीफाई करने वाला जो मैं बता रही थी कि आपको कौन सा डेटा नहीं मिल रहा है, कौन सा डेटा देखना है, तो आप ये लिंक डॉक्यूमेंट में जाएंगे। एफएसएल पे ना सर,
ये रिपोर्ट नंबर केस नंबर पे डीएनए 490 लिखा है, इस पे क्लिक करो।
इस पे
दो डेट इसमें आती है, जैसे हम रिपोर्ट रखते हैं मेरे साथ चलती रहा, अभी दोनों में ज्यादा डिफरेंस नहीं है वैसे। ये सारा स्टेटमेंट इसमें हमारा रिपोर्ट हमने रिपोर्ट लेके वो डिस्प्ले का बेल्ट है कि टाइमलाइन फिक्स रहे, हमारा कि 1 साल बाद डिस्पैच हो रही है, 2 साल बाद डिस्पैच हो रही है। ठीक है,
मैं डिटेल में कोर्ट का अगर डेटा देखना चाहूँ तो सीएनआर पे क्लिक करती हूँ। तो कोर्ट में जो भी डिटेल उनके एप्लीकेशन के थ्रू फील किया गया है वो यहाँ पर मुझे शो हो रहा है। इस कोर्ट में अभी तक की इस केस की क्या हिस्ट्री है वो पूरी देखने को मिल जाएगी मुझे। मैं आपको थोड़ी देर से लगाऊंगा, थोड़ी देर से आपको कॉल बैक करूंगा।
क्या होगा जब ये इंटरनेट होगा, आईसीजीएस में तो सब कुछ है ही नहीं, किसी भी प्रकार की आईसीजीएस से ना तो एडिट होती है ना डिलीट होती है, डाउनलोड होती है। वो सब आपके मेन के 10 में है। और आपको यहाँ लगता है, आपने यहाँ देखा कि ये मैंने डेट गलत डाली है, तो यहाँ से कुछ नहीं हो सकता, आपको फिर वो यहाँ रिफ्लेक्ट।
जैसे कि एक एग्जांपल देखिए, यहाँ पर जो है ये केस डिस्पोज हो चुका है, ठीक है। इसके बाद नेक्स्ट हियरिंग की जो डेट है वो आ रही है 1/1/1970, ठीक है। ये पॉसिबल नहीं है। तो ये अगर कोर्ट का पिलर अगर इस डिटेल को देख रहा है तो उसका स्क्रीनशॉट लेके उनका जो भी लाइक एनआईसी को भेज सकता है कि ये अपने आप से जनरेट होकर यहाँ डेट शो हो रही है। तो हमें डेटा एंट्री करेक्ट करनी पड़ेगी और सर्च करना पड़ेगा, इसे यूज करना पड़ेगा।
सब कुछ रेस्पॉन्सिबिलिटी हमारी।
हम प्रिजनर का अगर क्यों नहीं दिख रहा?
इसमें कुछ आईसीजीएस इंफॉर्मेशन कुछ दिखा रहा है, सब कुछ होगा आपकी कोर्ट पे डिलीट करना, ये करना सब कोर्ट। इसमें हम दिखा रहे हैं वो रजिस्ट्रेशन डेट, रिपोर्ट डेट और डिस्पैच, एग्जामिनेशन अलॉटमेंट वाली तो बात ही नहीं है। यहाँ शो ही नहीं हो, अलॉटमेंट वाली डेट को हम काउंट ही नहीं कर रहे हैं, अदरवाइज उससे और इश्यू आएगा ना कि अलॉटमेंट होता हमारे एक सही है, हमारे पास होता है चल रहा है, एक साल से उसको रखा हुआ है करके, तो इसके अलॉटमेंट वाले डेट को छुट्टी कर रही है, वो आपको दिख रही है अपने फोन पे, किसी अन्य पिलर्स का अलॉटमेंट, वो भी करेक्शन करेंगे तब वो आएगी, तो वो एक बड़ा है। लेकिन दो जस्टिफाई बने ना, आप एक साल में से जस्टिफाई करोगे, एक
चार्ज नहीं हो रहा है ये, निकाल दीजिए। इसका है ये। तो ये एक एक पिलर्स का जो डेटा है, हम लिंक डॉक्यूमेंट में जाके सभी का डेटा देख सकते हैं। ये जो फोटो यहाँ पे दिख रहा है, ये प्रिजन के थ्रू आया हुआ डेटा है। इसमें
करना होता है। वो एक बार गलती हो गई, वो हो गई। आपको दिखाना पड़ेगा ना वहाँ पे।
डैशबोर्ड का बता दें सर, डैशबोर्ड बता दें। तो सभी पूरा जो डेटा है आपको यहाँ पर आईसीजीएस में पोर्टल के आप आईडी ले लेते हैं तो आपको देखने को मिल जाएगा। इसके साथ में डैशबोर्ड की भी फैसिलिटीज है। आप पुलिस का डैशबोर्ड देख सकते हैं, सभी पिलर्स की डैशबोर्ड देख सकते हैं। जैसे अभी हम फॉरेंसिक की बात करें तो हम फॉरेंसिक का डैशबोर्ड देखते हैं। यहाँ हम फॉरेंसिक के डैशबोर्ड में सभी स्टेट, सभी एफएसएल और सभी एफआईआर का अगर हम डेटा देखें तो ये अभी लगभग 21 लाख 15 कुछ केसेस दिखा रहा है, 143 सेंटर्स दिखा रहा है, डिस्पैच हुए 6.82 लाख दिखा रहा है। तो मैं अगर मध्य प्रदेश सिलेक्ट करूं, यहाँ पे मुझे ऑप्शन दिया है, मैं इसको अपने अकॉर्डिंग इस डैशबोर्ड को चेंज कर सकती हूँ। तो मैं यहाँ स्टेट मध्य प्रदेश कर रही हूँ, अपना आरएफएसएल भोपाल सेलेक्ट कर लेती हूँ, डेट छोड़ के से अप्लाई कर देती हूँ। तो
देखिए इसको करिए। अब इसमें ये दिखा रहा है कि कितने केसेस हमारे पास आए हैं, उसका ग्राफ देखिए, हमारा डिस्टेंस ग्राफ बिल्कुल जमीन पर रखा हुआ। मैं ये बताना चाहता हूँ कि वो हमको दिखाई नहीं दे रहा है। इससे ये हो रहा है कि सेंट्रलाइज हम अगर अपने डेटा को देखेंगे तो हमारे यहाँ कमी तो बहुत ज्यादा है, लेकिन आउटपुट है ही नहीं हमारे रिपोर्ट में। हम कितने केस कर रहे हैं मतलब ये तो नंगा नंगा लगा दीजिए।
ये थोड़ा सा बढ़ गया है, तेलंगाना भी ऊपर जा रहा है। और ये डैशबोर्ड का पूरा एक्यूरेट भी नहीं है। हो सकता है ये मतलब इतने केसेस और ये मतलब डेटा एंट्री प्रॉपर ना हो तो डैशबोर्ड भी, क्योंकि पुलिस का डैशबोर्ड हम देखते हैं तो वो एक्यूरेट एमपी का तो ठीक है, लेकिन आप अदर स्टेट का भी देखेंगे तो अगर आपकी डेटा एंट्री प्रॉपर नहीं है, प्रॉपर जैसे मतलब कितने आपकी, ठीक है, आपने डेटा एंट्री करी, एफआईआर रजिस्टर्ड हुई, ठीक है, एफआईआर रजिस्टर्ड हो रही है, आपने डेटा एंट्री करी, ठीक है, और उस बीच में डेटा जो है वो पहले आपके पुलिस स्टेशन पे रहता है, फिर स्टेट लेवल पे जाता है, फिर एनडीसी पे जाता है, फिर आईसीजीएस पे आता है। तो इनके बीच में अगर कहीं गैप हो रहा है तो फिर वो यहाँ रिफ्लेक्ट नहीं होगा। तो डेटा का रिफ्लेक्शन भी मतलब एक इसका ड्रॉबैक है। तो वो भी आपको मतलब अगर आप ये आईडी यूज कर रहे हैं ना, तभी आप क्रॉस वेरीफाई कर पाएंगे कि जितनी डेटा एंट्री हुई है उतना पूरा यहाँ रिफ्लेक्शन हो रहा है या नहीं। और किसी के कोई क्वेश्चंस हो इसको लेके?
चलो तो सुबह नहीं किया, देर ही नहीं किया, न्यू क्रिमिनल लॉ का अच्छे अच्छे चीजें जो इस तरह हेल्प हो जाए तो क्या
हाँ
देखो कैसा आदमी, ये लाइट्स किसने ऑफ किया? देखो हमारा सिस्टम ऑफ नहीं करता है।
लाइट बंद कर दिए।
हाँ, हमारा सिस्टम ऑफ नहीं करेगा कोई।
मैं आगे करता हूँ।
क्या करते हो? छोड़ो सर, कल करेंगे ना।